I'm not ready to go yet, okay? I'm not ready. You gotta wait. I got shit to do. I'm in the middle of something, all right? Just hold on.
Watch your mouth or don't come in here.
Uh-oh. Uh-oh.
Oh, yeah, people, come on, we're adults here.
You know what? What is the point?
Yeah, we're adults here. I got a fucking Burger King fucking thing on my head. We're all fucking adults here, guys. People in my chat, 2 words. What are they? 2 words. Let me see the chat flood. Let me see the chat flood. 2 words. Okay. Next caller. Please. Let's get into the meat and potatoes, which translate in American to dick and balls.
I got flip-flops. These are my flip-flops. Yeah, I really like my flip-flops because I can put them on. Because look, watch me put them on. I can put them on all by myself. Watch me put them on. Look, are you watching? Look, these are my flip-flops.
Thanksgiving Day. I remember it clearly. It was Thanksgiving Day. I was inserting myself in somebody else's fucking business as a cash grab, and you know. This channel is harsh reality.
Karen Yak se jodió la sucia vida. Amen.
This is Jonathan Lee Riches. I have cheeseburgers. I'm gonna put cheese on them. I'm gonna make sure that I have my hamburgers because I'm a big boy now and I can make the hamburgers. My mom lets me use the stove now.
And I'm just like, wow, I like receipts, and they brought receipts. Like they had evidence to back up everything they said. And I'm like, okay, well, there's got to be another side to this, right? Like this can't. No, this is too fantastic.
Yeah, because you're not going to just jump to the conclusion that there's a conspiracy amongst cops to cover up a murder. You know what I mean?
Yeah, I mean, cops and just like soccer moms and shit. Like that's what made it even crazier. Like,
yeah, get it, Betty. Yeah,
did you have a close relationship with your mom?
Get it, Betty.
Oh, of course, I still do.
Yeah.
My older sister was kind of sad. She was more of the prissy girl that likes going.
That is the best shit fucking
shopping for dresses with mommy. I was the tomboy that liked playing with the feet.
Shout out to Cherry for just being easily the most faithful and loyal supporter that I've ever had, man. That someone could have that tenacity with loyalty. And I'm really blessed to have someone like Cherry be part of this channel and in my life. So it means a lot. And yes, I named him after Mr. T and Rocky. Say, woman. Say, woman. Say, woman. Since your old man ain't got no heart, why don't you come down to my apartment tonight and I'll show you a real man. Oh my God, I'm so in love with this little dude. Yeah, I'm going to go ahead and wrap this one up. I love you guys very, 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 very much. And we will do this again very soon, my friends. Oh, say bye. Say bye. Oh, I love you too. Give me a kiss. Oh, I love you. Bye, guys. Woo! People, good morning. Oh my goodness. I hope you all are as excited about today as I am. I don't know exactly what to expect of today. I think that we're probably going to hear some more tidbits out of that federal investigation, the findings, 3,100 pages. And I think that we are going to have a just more and more fuckery that is going to take place on social media involving this case. But we are going to be here for it. I don't know what to expect. I have no idea what to expect. Except hopefully we hear more and hopefully Judge Bev just dismisses the case, considering, I mean, to me it's just absolutely insane that she is even considering this going to trial at this point. I mean, at this point, you know, I don't see how the prosecution can effectively present a case that is going to sway a jury to a point to where the defense can't create doubt. I just don't see how that could even be a thing. What's up, VK? So Clubber's here. Clubber's just, he's laying here chewing on his toy. But I thank you guys for being here. I don't expect a whole lot of people to be here. I think Turtle Boy is streaming this as well. And I think a few other channels are streaming it as well. I think Brandy Churchwell, 13th Juror, is streaming this as well. I think, and then of course you've got Tom, who's out there live. So that's great. Capturing all those people. Let's take a quick look. Let's take a quick look at how things are looking out there. I was in that chat for a minute. And I'm going to keep checking Court TV's website for their feed. So here's Tom. What Tom's got going on outside. This is live.
It's cold out here. I'm sorry, guys, but I'm over here trying to get Karen coming out of the car. And little birdie told me that she's going to be coming on this side. So, kind of away from the crowd. I hope everyone's doing very well. It's cold out here. Still wind is what it is. Brian Hale Photography's here, taking some really good pictures. Dateline's here. Yeah. Our usual crowd. Usually tip. This is usually what we get for a good crowd.
I love
good turnout.
I love that what's up, Tracy Ann Chasing? It's good to see you. Good morning. I love that Dateline is there. That means I'm predicting a different perspective coming from Dateline. Now Dateline is smart. Dateline will wait. Dateline is not a tabloid. Dateline will wait until all the facts are in before spinning a certain narrative. At least I like to think they would. So I'm guessing we're gonna get a different take from Dateline than we have been from the Court TV, for instance. And that's no offense to Vinny. I know Vinny's trying, man. Vinny's trying. Vinny's doing his part. I love it. But let's hear what Tom has to say while I check on
Delivery.
other streams here.
Who's streaming?
Well,
They're doing my stream? Okay. Cool. Cool.
Let me say hi to Cherry.
Yeah. Cherry.
Hey, they're giving us a shout.
Cherry's awesome. It is? Definitely? So she's got to get out this way then. Okay. The vehicle. We have the target. There's for people in it. There it is. There it is. Hey. Yep. How are you, sir? Good to see you.
Look at that. Look at that.
All right, I'm going to cry.
They look like such nice people.
Well, there you go, guys. Just did my best getting that for you. Didn't want to jump in no one's way.
We appreciate you, Tom.
Let them go, you know? Yeah. Nice.
Oh, give it up for Tom, y'all.
You see her dad? Her dad, man, that just giving everyone high fives and just shaking hands and oh my, talk about freaking awesome.
Now I wonder,
Just awesome. Really. I mean,
I wonder while we look at these beautiful people here, because these people are amazing. Hold on, we got to give them all those people out there. Now I wonder if if Karen Reed's family showing these supporters a little extra love today, if that means that they know something is going to happen in court today, or they, they're aware of the strategy and have a certain expectation of the outcome, considering whatever they were briefed by Yannetti and Jackson. I'm sure they get constant reassurance from Yannetti and Jackson. I would hope so. They're expensive. So I would hope that they're getting constant reassurance, Karen's family. But I wonder if them showing a little extra love to the supporters out here, if that means that they know a little something more than what they're used to. Oh my goodness, what? It's too early. It's too early, Buzzy.
I think we got a super dad. Super dad. I think we got a super dad. Super dad. Super dad. Super dad. I think we got a super dad.
Thank you, Buzzy, for truth. I appreciate you. All right, let me check in on Court TV here. Still nothing. I don't know. I think Young Jerks might be live. I don't know if he is or not. I know that Broken Baker is live, and I know that Brandy Churchill, 13th Juror, is live as well. And I know Turtle Boy is live, and I think LTL might be with him. I don't know. Tracy Ann, oh my goodness, Tracy Ann.
I think we got a super dad. Super dad. I think we got a super dad. Super dad. Super dad. Super dad. I think we got a super dad. I think think we got a super chat. I think we got a super chat.
Dance your butt off, Ryan. You're famous now. Thank you, JCN. Oh, and I just got a Venmo from Tara. Thank you, Tara. I appreciate you so much. Oh, that's cool. I got a notification through my laptop about that. I hope that happens every time so that I don't miss any when they happen. Okay, so LTL's not with Turtle Boy? Okay.
I think doesn't 5 does it, don't they? 25 does it. 25 was louder. But 25 was louder last time. Remember, we couldn't hear it. My other one like this.
Thank you, Gerda K. Diana, congratulations.
You broke it good.
Oh,
Happy birthday.
There's no particular reason. I just set the live stream because I planned on streaming it. And it's I don't know. I didn't know what Aiden was going to do. I didn't want to assume that I would be streaming live with him. So I set a live stream up for this a couple days ago. So I just didn't know what his plans were, if he was going to go, if he wanted to do this again. All he has to do is ask, and I'm there. But I just didn't know what his plans were, and regardless, I have a commitment to all of you who follow me as well. So I wanted to make sure that regardless of what happens and what was going to be set up, you guys were going to be able to catch this hearing. So, but yeah, we just didn't set one up this time. That's all. Let me see. All right. All right. So right now they've got this direct examination of the farmer who testifies against finding a victim's charred remains. Oh, Jesus. That's dark. But they're not going to want to miss this, I'm sure.
I think we got a super chat. Super fan. I think we got a super chat. Super fan. Super chat. Super I think we got a super chat. I think we got a super chat.
Oracle Blinn, thank you so much. Thank you, Will, Cherry, and Turtle Boy, Tom, and all of the Karen supporters. Justice for Officer John O'Keefe. Let's hope today is the day. I agree. Let's hope today is the day, Oracle. And thank you so much. Appreciate you. Let me take a look. I'm gonna leave Tom's sound on while I do this.
Wow, that wind is crazy. Wow. Let these people in. What's up? It's 9 o'clock.
It's 9 o'clock. Let's go.
What's up?
Public
They
building.
get to walk right in.
Yeah, public building. Let's go. Pay taxes.
Why do they get to walk right in?
Next time we're all gonna walk.
That ain't right.
We're with the Karen Reed
right. I don't know what's going on there. I guess like some people who shouldn't get to walk right in got to walk right in. Aiden, Turtle Boy, I don't have a link just yet. If I get one, I'll send it to you, buddy. I'll be happy to do that. But I don't have a link yet, but as soon as I do, I will shoot it over to you on Twitter. But in the meantime, I just love to see what Tom is doing, man. So Channel 5 is there. So I'll check them as well, and I'll be checking oh, Paul James, thank you so much. I appreciate the Cash App. It's very nice of you. Oh my goodness.
I think we got a super chat. Super chat. I think we got a super chat. Super chat. Super chat. Super chat. I think we got a super chat. I think we got a super chat.
Okay, thank you so much, Lori. Justice for John O'Keefe is coming. I agree.
Of course, it's a motion for dismissal today, so we'll see what happens. Hopefully, she doesn't put it under advisement like she has in the past, and maybe a righteous decision could be made today, but that's in the Lord's hands, so we'll see what happens with that.
All right, man. Thank you.
Thank you,
Do you have
brother.
anyone you want to say hi to?
I'd like to say hi to my wife.
There you go.
I'd like to say hi to Kate, my friend.
Nice.
Of course, my brother right here from another mother.
That's your brother?
From another mother.
All right.
Good old Scott McGinnis here.
He's Scott's friends with us. Scott's my guy.
He's good peeps.
Yeah.
He's good peeps.
No doubt.
And as you, hey, by the way,
Yes.
you like to fish.
Love fishing,
So,
guy.
brother, you and me got to get together.
Let's go. I got a bass boat.
Good. We'll go.
I
We'll go.
got
Absolutely.
19-foot bass cat with the 200 out the back.
Let's go.
I got that new motor guy, trolling motor.
Yeah.
Spot lock. You just hit the button.
Yeah.
Don't let the wind blow. It don't matter. I love it.
It's great.
Yeah.
Is Aiden gonna panel with the glare?
I don't know. I don't know. Grant's at the doctor. Okay, hope he feels better.
Who's at the doctor?
Grant,
Oh, God bless.
God bless him. No. What I did, no, don't. I went over, I said, listen, we're going to do a moment of silence, okay? I don't care about your moment of silence. Listen, if you're going to say something like that, be that rude, I walked away. I didn't talk to him again. I'm all done. 5 seconds for someone that died. I mean, you can't give somebody that. You're that selfish of a prick. You can't do that. You can't give up 5 seconds. No, fuck off. I'm all set with it. Erica,
Hi.
how are you?
I'm okay. How are you?
Good. You want to say hi?
Hi, everybody. What's going on?
A little warm?
Yeah, no, absolutely not. My fingertips are falling off. How you doing today?
Good. What do you think about today? Give us some good something. Give us something.
I think we're gonna hear some decent news today. Yeah, we'll see. But I think it's gonna be a good day. I do. I think it's gonna be a good day.
Nice.
Got all these people in line already.
Yeah, it's 9:10,
Here we go.
and they're not being let in.
Right.
But the other side gets to walk right in.
Right past her family too. Right past her family too.
Unbelievable.
Absolutely. Absolutely.
That's just not right. I'm sorry.
Here comes the rain.
Yep. Oh, it's gonna rain, all right.
Everybody okay?
Yeah.
How many people you got? There you go. Nice.
No. I had
Yeah, like you said 17 something, right? Beautiful.
2,400 something. Yeah.
Make sure you guys like and subscribe.
Yeah, I gotta hit that like button, guys.
We have to allow.
YouTube. Yeah, the bridge fell down. Bridge in Baltimore fell down.
All right. This is what I've got so far. This is all I've got so far. I'm going to keep okay, let me see. It's sorry guys, I'm just trying to I'm still looking for a link to get this like a news link, just so that they have better so we have a better visual of everything. I just have that pulled up just in case as a default, but okay. Okay, so hopefully maybe I just don't see Court TV not doing it. I just don't think that they have um yeah, no, I'm not seeing that either. Let's try that. All right, so and I have Boston 25 pulled up. Sorry guys. Again, like people seem to be shuffling in there. And I have the sound all the way up, so when there's sound there will be I'm just looking for another news source. I'm looking for a news source that has the live feed. Um, yeah, guys. Like I said, I'm just waiting for like Court TV. Court TV is usually pretty reliable. Now I don't know what Aiden is using to stream or LTL. I don't know which either one of them is using to stream, but um for now we've got the live direct feed from the Zoom call. So we'll do that for now until something comes up. I just tried NBC Boston. It's just there's no feed. All right. There we go. That's not live, Sherry. It's just a 30-second story. Oh, wait. Hold on. This is supposed to be live. Hold on. We got something here. All right. The volume's pretty low. It is Boston 25. Sorry, but and I can't full screen it, which I don't understand why. It won't let me hit full screen, which is quite annoying. And now there's no sound coming through. So I don't know. I'm going to keep checking Court TV because Boston 25 let us down last time. And I'd really prefer not to make that same mistake again. Yeah, like it's just every time I refresh it, it does that. Like it'll play the same sound and then it's the same thing and then it freezes and stops. I can't even full screen it. Says it's already on full screen. It's like exit click to exit full screen. I don't know what's going on with Boston 25 right now. But like I said, I'm going to keep refreshing Court TV. Like I'm going from their website too cuz that's usually the best thing that they have got going on. Okay, so this is different. Yeah, why is this saying that this is 11 minutes long when I'm
Thank you. Happening today, the woman accused of killing her police officer boyfriend is back in court for one of the final hearings before her murder trial begins. Karen Reed is accused of backing her car into her boyfriend, John O'Keefe, in the middle of a snowstorm in Canton. At 5 and 6.
You could earn your degree online at South University now. If you're working full-time, you could earn your degree online at South University, and classes.
Something's happening here. Let me see something here. No. Oh, okay. All right. I'm hearing something here. You guys hear that?
Now with breaking news. This is Boston 25 Morning News, your local station.
We continue to stay on top of breaking news here at 9:30. Search and rescue crews continue to look for possible survivors after a ship strikes a bridge in Baltimore, sending the whole thing plunging into the river below.
And there were cars and construction workers on the bridge at the time of the impact. Here's a live look from that scene right now. And city officials say the top concerns remain trying to find people who may be in the water. Boston 20.
Now, this is the link that Turtle Boy just sent me. And thank you for that, Turtle Boy. Appreciate you. That's as loud as it goes, guys. There's nothing I can do about the sound, so please don't start blasting the chat about sound.
Good morning, Mr. Henchy. Good morning, Mr. Jackson, and good morning, Ms. Reed. All right, so in court are counsel who will argue the motions for today. There's only Mr. Henchy and Ms. Unetti. When I set dates on the modified scheduling order, I set dates that were convenient to the parties.
Now, the sound is way better on the other feed that I had up.
Motion, but I see Mr. Jackson chose not to be here today, and so counsel will argue the motion here this morning. So, but before we begin, told repeatedly from both Mr. Jackson and Ms. Giannetti, and I do understand completely that Ms. Giannetti cannot be here today. He's certainly excused from being here. But I was told that there would be a motion for a
that he would put in the body of the motion how it was different. And he assured me as recently as last week that that motion would be filed later that day. So that motion has not been filed. That motion then is waived. So what we have today are two motions regarding Rule 14 obligations. So who's going to argue? Is it Ms. Giannetti or?
I will be arguing.
Okay, so I need you at a microphone. So I will hear you on the motion where you're looking for notes, reports, memoranda, and logs.
Thank you. Your Honor, at the outset, I just want to note that as this court is aware, we have a motion pending before the court to disqualify the Norfolk DA's office from this case. Our position, therefore, is that the DA's office should not be participating in this case or arguing any motions, including this one. And I raise this issue just to alert the court that we are not waiving any objection to their continued involvement in the case.
Okay, so I haven't decided that because I was waiting for the motion for egregious conduct, motion for sanctions or motion to dismiss based on egregious governmental misconduct, because I needed to be assured that that was different than the motion to disqualify. If I had known it was not coming, and maybe no intention of filing it, I would have decided that motion by now.
Your Honor, it was a strategic decision for us not to file that motion. It's not because it wasn't meritorious. It was a strategic decision only.
All right. You made representations that you were. Therefore, the other motion, I have not acted on that yet.
I just want you to note the objection, please.
Yeah, the objection's noted. So please move on to the merits of your discovery request.
Absolutely. Your Honor, we're asking for material that fits squarely within the parameters of Rule 14. Statements were made to investigators in this case, including to Mr. Lally and to his staff, and in certain conversations, the state police were even present. Statements of witnesses are simply discoverable. Although they lodged general objections to each of our requests, and these were really boilerplate objections, the Norfolk DA's office appears to be arguing that these witness statements contained in their notes of their conversations, multiple conversations, are all work product. Neither this court nor we are in a position to judge whether the notes are strictly work product without actually seeing the notes. Work product is defined as legal research, opinions, theories, or conclusions. And to be clear, we are not interested in the Norfolk DA's office's opinions, theories, or conclusions. To the extent that these notes contain work product along with the statements, we are fine with the work product being redacted. We are not interested in their work product, but it is important for us to know whether their notes contain any statements of witnesses, and if they do, they should be turned over to us. Otherwise, discoverable material is not off limits simply because a prosecutor writes something in the margins of a document. That would give an attorney the power to keep otherwise discoverable materials out of the hands of a party who should legally be entitled to see the material. At a minimum, Your Honor, this court should order the Norfolk DA's office to disclose whether its notes contain any statements. They have not disclosed that. If the notes contain any witness statements, and if the Norfolk DA's office is objecting to producing them to the defense, then this court, we're asking this court to have the DA's office produce those notes to the court so that this court can conduct an in-camera review of those notes, of their notes, and evaluate whether they are truly all work product or whether there is in fact discoverable material contained therein. Beyond that, Your Honor, we would rest on our motion in our brief.
Okay, thank you.
Thank you.
Mr. Lally, your response, please.
Yes, sir. And Your Honor, I'll be brief. So essentially what the defendant's motion seeks is And I would object to the mischaracterization of every single phone call or conversation with a witness as an interview with a witness. But I'm not even sure what half of these are referring to, as I don't recall any of those specific meetings occurring. Or as a result of a simple explanation as to Rule 17 motions that have been filed for individuals' phones or phone records or other third-party records that they were the subject of. It's a boilerplate response because it's a boilerplate law that applies in this case as far as work products that applies to each and every one of the requests, with the exception of number 8, of which the Commonwealth has no objection to that.
Explain to me how work product applies.
Your Honor, work product applies and specifically in reference to, it's contained within, and I would largely rest on the Commonwealth's motion, but it's contained within what's cited as Beng Sia Liang in regard to interview notes in preparation of testimony is work product under the case law, under the rule of criminal procedure. Whatever notations may be contained within those. But essentially, these are not statements as are defined under Rule 14 from any of these conversations with witnesses. Rule 14 doesn't apply to these statements, number one. But secondly, if there is any content, it's either already been provided through the course of discovery, whether it be contained within a police report, grand jury minutes. There's nothing different than what has already been provided. And then secondly, what the case law states and what Rule 14 states is that these types of conversations with witnesses, whether reduced to writing or not, are within the ambit of the work product doctrine.
All right. Any response? You don't necessarily have to, but I just want to see if you want to.
I would just say, Your Honor, their opposition to our motion does not even acknowledge whether there are statements or not.
It was in large part me talking as far as explaining the law and things of that nature. There were not any statements related to the case or any testimony that was discussed or anything of that nature. The one thing that I was referring to is there is one request that does deal with a meeting which involves preparation of a witness for grand jury, and whatever that witness indicated in the course of that was testified to before the grand jury and is contained within the minutes and contained within police reports of interviews with that same witness. So there's nothing to report.
All right. All right, then.
The sound is
motion
better the other way,
is
so you guys let
Commonwealth's
me know.
motion for reciprocal discovery. But before we begin with that, Mr. Lally, could you tell me what reciprocal discovery has been provided to the Commonwealth at this point?
Nothing. Absolutely nothing.
All right. So trial is 3 weeks from today. When did the Commonwealth provide its certificate
So the Commonwealth is
compliance?
unable to file its certificate of compliance at this point. The one, I would say, sort of primary piece that we're waiting on is there were 2 rounds of DNA testing that were done at the Bodie Lab in Virginia. One of those was completed. That was in regard to the defendant's taillight. That was finished, I think, first week of March, and counsel already has all of that. The second piece is in relation to the hair from the rear of the defendant's vehicle. Just for sort of review purposes, that was something that had gone or undergone sort of typical DNA testing, which is autosomal DNA testing, which is taking the profile from, or attempting to take the profile from the nucleus of the cell, and it relates to essentially both biological parents. That sample was of insufficient quality or quantity to generate a sample under the autosomal. So we had asked, and the court had ordered, for the mitochondrial DNA testing, which goes to the maternal side only. And the Bodie Lab is able to do that. My latest update from that, and I say all that just to build up as to a sort of caveat as far as the testing is concerned. So the initial estimate as far as the testing was would put us several weeks out. We had asked that it be expedited. We had paid for it to be expedited. And the quickest that they can turn around a report would be sometime in mid-April. The caveat to that is whether or not there is a sufficient quantity and quality for them to generate a mitochondrial DNA profile from the sample. That I should have an answer to, I was told, by the end of the month. So hopefully by either the end of this week or very early next week, because obviously if they aren't able to generate a mitochondrial DNA profile from the sample, then there's no reason to generate one from the victim and do a comparison. So that would sort of end it there, and then we would then be able to file the certificate of compliance.
Oh, that's not me breathing into the mic, by the way. That's fucking
Every
Auntie
other aspect of
Bev.
the case, as I mentioned, there was number 8 in the defendant's motion to compel that we should have to them by the end of this week, if not earlier. So every other aspect of the case, as far as discovery goes, should be done from the Commonwealth's perspective, and that's the reason that I filed the motion, Your Honor, at this time, understanding that they're not obligated under the rules of criminal procedure to provide anything, but given that we have an April 16th trial date and I have nothing as far as any sort of reports or notice of experts or testing or anything really at all, I'd appreciate being able to get that, review that, or at least see it, prior to the day we're impaneling.
All right. What do you say, counsel?
Ron, as you know, we do not owe them any reciprocal discovery until they file a certificate of compliance, which has not been done. I mean, we have received hundreds of pages of documents. I mean, 4 days ago, we received like 400 pages of documents we haven't gone through. Counsel just handed us a thumb drive with, I don't know what's on this thumb drive. We have to go through that. So we haven't given any reciprocal discovery because we are not obligated to do so.
Do you intend to call experts in areas other than DNA?
I'm going to have to defer to Mr. Jackson, who is on Zoom.
All right, but counsel to arguing these motions was to be present here in court today, right?
Your Honor, if I can be heard for just a second on that issue, Mr. Lally made it very clear that given the fact that he was not in compliance with his discovery obligations, that this motion was not to be heard today. So this is sort of coming out of nowhere.
No, hold on. So Mr.
Dude.
Lally doesn't decide what motions were to be argued. Today was for all non-evidentiary pretrial motions were to be argued. This was filed timely. This was on for today. If you feel that you cannot argue it, that's a different story.
What? What is with this lady, man?
So you are muted.
Wow.
All right. Mr. Jackson, you're muted.
See, I had the direct feed to
I don't know
this.
how I got muted. Yes, we are intending to call experts, and there are going to be experts that are in areas other than DNA as well. But we haven't provided discovery because we don't even know what the 400 pages that or 500 pages that we just got 3 or 4 days ago include, nor the discovery that was handed to us this morning. As soon as the Commonwealth gets finished with their compliance obligations, we will then comply with our discovery obligations. We have every intention of doing so, and we're fully prepared to do so. We're waiting on them.
So once you get it from the Commonwealth, you can have it in a matter of a day or so, other than the DNA?
Well, I don't know if I can do it in a day.
What?
But
Well,
once we have full
You do know, if you're calling witnesses, you know who you're calling, correct?
I have an idea who I'm calling, yes.
All right, and you've engaged experts, so you've been working with experts, so you should have all that information ready to disclose, correct?
We're in the process of getting those decisions finalized, yes, but some of them are going to be predicated on what the Commonwealth discovery and the totality of the Commonwealth discovery looks like.
No,
I mean, that's their obligation.
No, I understand. All right, but you will be calling witnesses and you will be calling expert witnesses?
Absolutely.
All right.
Of course.
What is your estimate as to how long this case will take to try?
I assume if the Commonwealth case, I'm just throwing a dart at a dartboard, but based on what I know, if the Commonwealth case takes 3 to 4 weeks, I think our case would probably take 2 weeks.
Okay. All right.
Yeah,
Valley, I suggest that you
half
get
the
that
time to just
information as soon
shoot
as
their 4
possible.
weeks down.
It could be that I strike it, but I would hear from the defense on that as well. But at least find out if they're able to do the testing.
Yeah, sure.
All right. All right. Thank you. You have your next date. We'll see you then.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, Mr. Sport.
So that's it. Just basically a big fat nothing burger. Like jack shit. So basically just a Judge Bev snark fest at Alan Jackson. I mean, what was her deal, dude? Like, we gotta watch all this again. I'm playing all this all over again.
Before we begin, I have been told repeatedly from both Mr. Jackson and Mr. Yannetti, and I do understand completely that Mr. Yannetti cannot be here today. He's certainly excused from being here today. But I was told that there would be a motion for a motion to dismiss based on egregious government misconduct. I was told that by both Mr. Jackson and Mr. Yannetti. I asked Mr. Yannetti how that motion to dismiss was any different than the motion for sanctions and motion to disqualify the district attorney's office.
I mean,
He assured me
basically what I got out of everything we just watched was, so this is a motion for a non-evidentiary hearing. I basically what I got out of that was that the Commonwealth is saying that they want certain information, certain evidence from the defense, but the defense is like, why should we give up any evidence if they haven't given us any evidence? We're still waiting on them to give us certain evidence so that we could still put our case together. But so she asked Alan Jackson, which I found noteworthy, how long she thought that it would take to present their case. If it's going to be the Commonwealth 3 to 4 weeks, it's going to take them to present their case. It would take them 2. So half the time basically to just shoot their case down. I mean, I just don't see how the Commonwealth is I don't see how the Commonwealth is gonna try this case where this defense team, any defense team really, but this defense team especially, isn't going to just be able to just shoot everything down that they present. It's fascinating to me. But I'm trying to get a handle on Judge Bev here. So we're going to stay live for a while because I really want to break this down.
it was in fact different. He assured me that he would put in the body of the motion how it was different. And he assured me as recently as last week that that motion would be filed later that day. So that motion has not been filed. That motion then is waived. So what we have today are two motions regarding Rule 14 obligations. So who's going to argue? Is it Ms. Yannetti or? Okay, so I need you at a microphone. So I will hear you on the motion where you're looking for notes, reports, memoranda, and logs.
Thank you. Your Honor, at the outset, I just want to note that as this court is aware, we have a motion.
I mean, why is Judge Bev so nasty, dude? You know?
Pending before the court to disqualify the Norfolk DA's office from this case. Our position, therefore, is that the DA's office should not be participating in this case or arguing any motions, including this one. And I raise this issue just to alert the court that we are not waiving any objection to their continued involvement in the case.
Okay, so I haven't decided that because I was waiting for the motion for egregious conduct. motion for sanctions or motion to dismiss based on egregious governmental misconduct, because I needed to be assured that that was different than the motion to disqualify. If I had known it was not coming and maybe no intention of filing it, I would have decided that motion by now.
Your Honor, it was a strategic decision
Okay.
for us not to file that motion. It's not because it wasn't meritorious. It was a strategic decision.
All right. You made representations that you were there.
I gotta understand. See, that got me when we were listening to that earlier, because, well, what's the strategy there? so far, I gotta say that Alan Jackson and David Yannetti's strategy has been reassuring. But I don't know what this is. And I'm not saying I have no faith in them. I have all the faith in them in the world. I'm just curious as to what this strategy is all I'm saying.
Therefore, the other motion, I have not acted on that yet.
I just want you to note the objection, please.
Yeah, the objection's noted, so please move on to the merits
Yes.
of your discovery request.
Absolutely. Your Honor, we're asking for material that fits squarely within the parameters of Rule 14. Statements were made to investigators in this case, including...
Now, before I continue real quick, I got to acknowledge there's 200 folks watching from YouTube, but there's 577 people on Twitter watching. So thank you guys on Twitter for watching. I appreciate you.
Lally and to his staff, and in certain conversations, the state police were even present. Statements of witnesses are simply discoverable. Although they lodged general objections to each of our requests, and these were really boilerplate objections, the Norfolk DA's office appears to be arguing that these witness statements contained in their notes of their conversations, multiple conversations, are all work product. Neither this court nor we are in a position to judge whether the notes are strictly work product without actually seeing the notes. Work product is defined as legal research, opinions, theories, or conclusions. And to be clear, we are not interested in the Norfolk DA's office's opinions, theories, or conclusions. To the extent that these notes contain work product along with the statements, we are fine with the work product being redacted. We are not interested in their work product, but it is important for us to know whether their notes contain any statements of witnesses, and if they do, they should be turned over to us. Otherwise, discoverable material is not off limits simply because a prosecutor writes something in the margins of a document. That would give an attorney the power to keep otherwise discoverable materials out of the hands of a party who should legally be entitled to see the material. At a minimum.
See, I'm confused here. I'm confused because, as I understand it, in one of the motions that the defense filed, I believe it was the motion to dismiss, it stated that when they asked the Commonwealth for these notes, they responded that the notes no longer existed. So I'm confused here, because if the notes, are they still filing to see the notes? And the Commonwealth is saying, well, under Rule, I guess 14 or Rule 17, I can't remember. He says so later. Lally says so later, but apparently there's a rule where if it contains work product, well, the defense doesn't have a right to see it. But they're saying they're not interested in the work product. They're interested to know if there's anything personal going on. They're looking for exculpatory evidence against or exculpatory evidence for Karen Read. And they're thinking in these notes or any recordings or anything like that they could find something like that. But I don't know, man. That sounds like fishing. That I gotta be completely honest. That right there sounds like fishing. But again, it doesn't mean anything other than they're gonna have a hat full of tricks. You know, it's their job. They're the defense. They're going to have a hat full of tricks. But so this is interesting to me because I don't think, I just don't see, like, you know, if they can't review the work product, which I don't understand why they can't do that. That's what I don't understand. I don't understand why, for some reason, the defense doesn't have a right to see their notes that they took in order to reach the product of documentation and evidence. You know what I mean? Any witness statements. If they recorded a conversation and then wrote the statement later, typed it out, you know, these kind of things are going to say a lot. But I didn't know that the defense didn't have a right to subpoena these things.
Minimum, Your Honor. This court should order the Norfolk DA's office to disclose whether its notes contain any statement.
Oh,
They have not disclosed that.
No, man. Listen, I'm down to do more streams with Turtle Boy and LTL or whoever. I'm always down to do streams with other people, man. I just set this up and we're doing it. That's all. That's all. We just didn't happen to contact each other about this one. That's all. I didn't know what he was going to be doing. So that's all. I'm sure we'll work something out in the near future again soon, guys.
If the notes contain any witness statements and if the Norfolk DA's office is objecting to producing them to the defense, then we're asking this court to have the DA's office produce those notes to the court so that this court can conduct an in-camera review of their notes and evaluate whether they are truly all work product or whether there is in fact discoverable material contained therein. Beyond that, Your Honor, we would rest on our motion and our brief.
Okay, thank you.
Thank you.
Mr. Lally, your response, please.
Yes, And Your Honor, I'll be brief. So essentially what the defendant's motion seeks is, and I would object to the mischaracterization of every single phone call or conversation with a witness as an interview with a witness, but I'm not even sure what half of these are referring to, as I don't recall any of those specific meetings occurring. But if there were meetings, any meeting with a witness post grand jury was in reference to either harassment that they were sustaining as a result of actions of others,
Oh my God.
or as a result of a simple explanation as to Rule 17 motions that have been filed for individuals' phones or phone records or other third-party records that they were the subject of. It's a boilerplate response because it's a boilerplate law that applies in this case as far as work products that applies to each and every one of the requests, with the exception of number 8, of which the Commonwealth has no objection to that.
Explain to me how work product applies.
Your Honor, work product applies it specifically in reference to, it's contained within, and I would largely rest on the Commonwealth's motion, but it's contained within what's cited as Beng Sia Lang in regard to interview notes in preparation of testimony is work product under the case law, under the rule of criminal procedure. Whatever notations may be contained within those. But essentially, these are not statements as are defined under Rule 14 from any of these conversations with witnesses. Rule 14 doesn't apply to these statements, number one. But secondly, if there is any content, it's either already been provided through the course of a police report, grand jury minutes. There's nothing different.
Why does Boston 25 always do that? Like improve their sound halfway through?
What the case law states and what Rule 14 states is that these types of conversations with witnesses, whether reduced to writing or not, are within the ambit of the work product doctrine.
All right. Any response?
I
You
mean,
don't
like,
necessarily have to, but I just want to see if you want to.
I would just say, Your Honor, their opposition to our motion does not even acknowledge whether there are statements or not statements. I just heard Mr. Lally say that there in fact are statements. So I am going to ask again that this court take those notes there and go through it and in camera and decide whether in fact all of it is work product or whether there exists within it discoverable materials with statements of witnesses. And I find it hard.
okay, so what the defense is proposing, which is not unreasonable, you know, they just want to make sure, okay, well, all right, so so we don't break any rules here, so we don't hurt anybody's feelings. How about if we have the judge on camera review the notes and determine for herself whether or not these notes are just work product or if they contain personal exchanges that could be exculpatory for Karen Read, considering these witnesses that they're talking about. They want the notes of Proctor with McCabe, with the McCabes. They want the notes of Proctor interviewing anybody that was inside that house. They want to know what the hell's going on. And if any of these notes contain anything that show a personal interest, or otherwise. So I could see why they want it, but I mean, I don't feel like it's absolutely necessary if they get it. I don't see Judge Bev being like, okay, you know, but we'll see.
Hard to believe that there wouldn't be any statements of witnesses concerning this case. Thank you.
Do you want to respond at all?
Your Honor, again, with reference to the, as they term them, interviews, but essentially phone calls with witnesses, these were in regard to explaining to them the Rule 17 process, explaining to them what counsel had filed, what types of records were being requested. It was in large part me talking as far as explaining the law and things of that nature. There were not any statements related to the case or any testimony that was discussed or anything of that nature. The one thing that I was referring to is there is one request that does deal with a meeting which involves preparation of a witness for grand jury. And
let's think about this for a second. What if something is really fucking incriminating? You know what I mean? Like, what if there's a recording of Jen McCabe and Michael Proctor talking? And I'm just speaking hypothetically here, you know? What if there's in these notes something that is absolutely damning, right? Something that is just like a bombshell of like, holy shit, something that could blow the 227 search out of the water as far as like holy fuck, what happened? I can't believe she did that. Let's say that happens, right? And then let's say that if I wonder, like, she has a right to an attorney, right? So, but the thing is she's speaking to an investigator. So are her rights being violated if they look at the stuff that's supposed to be on or off the record? Of course her rights are not being violated because she's speaking to a direct investigator on the case. And if there's something incriminating against her, well, then it's up to that investigator to do something about it. And if he's leaving it out of his official reports, well, then that's corruption. That is straight up fucking corruption. That is a cover up. So I don't see if something like that, I don't see the defense coming about this easily. So yeah, I would be surprised if they still existed. I would absolutely be surprised if any evidence like that still existed.
Indicated in the course of that was testified to before the grand jury, and it's contained within the minutes and contained within police reports of interviews with that same witness. So there's nothing to report.
All right. All right, the next motion is the Commonwealth's motion for reciprocal discovery. But before we begin with that, Mr. Lally, could you tell me what reciprocal discovery has been provided to the Commonwealth at this point?
Nothing. Absolutely nothing.
Oh, poor baby.
Right. So trial is 3 weeks from today. When did the Commonwealth provide its certificate?
So the Commonwealth has
compliance.
been unable to file its certificate of compliance at this point. The one, I would say, sort of primary piece that we're waiting on is there were 2 rounds of DNA testing that were done at the Bodie Lab in Virginia. One of those was completed. That was in regard to the defendant's taillight. That was finished, I think, first week of March, and counsel already has all of that. The second piece is in relation to the hair from the rear of the defendant's vehicle. Just for sort of review purposes, that was something that had gone or undergone sort of typical DNA testing.
See, it's just shocking to me that they're even like bothering spending the money and the resources to test if that hair belongs to John O'Keefe on the bumper of the car, because it was his girlfriend's car. His hair could have gotten there at any point in the evening. His hair could have gotten there putting away groceries. His hair could have gotten there pulling out a spare tire, putting one in. His hair could have gotten there doing an infinite number of things. His hair could have gotten there walking by and the wind blowing and landing on her bumper. I mean, it was his girlfriend's car. I don't even see how the Commonwealth can't see that that would be the most simple argument against that. I mean, you know, like, it makes no sense that the Commonwealth is even and this whole thing is bizarre that it's even going this far. It makes no sense that this has gone as far as it has.
DNA testing, which is autosomal DNA testing, which is taking the profile from, or attempting to take the profile from the nucleus of the cell, and it relates to essentially both biological parents.
So you're saying that
sample was of insufficient quality or quantity.
So you're saying that the typical DNA profile testing is inconclusive. So now the Commonwealth is asking for extra testing. Wow.
Quantity to generate a sample under the autosomal. So we had asked, and the court had ordered, for the mitochondrial DNA testing, which goes to the maternal side only. And the Bodie Lab is able to do that. My latest update from that, and I say all that just to build up as to a sort of caveat as far as the testing is concerned. So the initial estimate as far as the testing was would put us several weeks out. We had asked that it be expedited. We had paid for it to be expedited. And the quickest that they can turn around a report would be sometime in mid-April. The caveat to that is whether or not there is a sufficient quantity and quality for them to generate a mitochondrial DNA profile from the sample. That I should have an answer to, I was told, by the end of the month. So hopefully by either the end of this week or very early next week, because obviously if they aren't able to generate a mitochondrial DNA profile from the sample, then there's no reason to generate one from the victim and do a comparison. So that would sort of end it there, and then we would then be able to file the certificate of compliance.
All right. Every other aspect of the case, though?
Every other aspect of the case, as I mentioned, there was number 8 in the defendant's motion to compel that we should have to them by the end of this week, if not earlier. So every other aspect of the case, as far as discovery goes, should be done from the Commonwealth's perspective, and that's the reason that I filed the motion, Your Honor, at this time, understanding that they're not obligated under the rules of criminal procedure to provide anything, but given that we have an April 16th trial date and I have nothing as far as any sort of reports or notice of experts or testing or anything really at all, I'd appreciate being able to get that, review that, or at least see it, prior to the day we're impaneling. I filed the motion. Your Honor, at this time, understanding that they're not obligated under the rules of criminal procedure to provide anything, but given that we have an April 16th trial date and I have nothing as far as any sort of reports or notice of experts or testing,
So
anything really, provide anything, but Your Honor, at this time, understanding that they're not obligated under the rules of criminal procedure to provide anything, but
they're not under the rules of criminal procedure to provide anything, but I'm gonna bitch about them not providing anything anyway. Like, why do you want what the defense has? You know what I mean? Like, they're only obligated to provide this in their motions to dismiss and disqualify because they're making accusations. Now, in this, when it comes to just simply defending their client, they're not obligated to give you shit. And the fact that this dickhead has the audacity to stand there in court and plead to the judge and act like a victim to the judge that the defense isn't providing something to them is fascinating to me, when this dude has not provided any discovery or has failed to provide plenty of discovery to the defense. And then Judge Bev even orders it, but when they say, nope, we're not giving it to you because it no longer exists. Well, Judge Bev is like, whatever, and then makes a joke. She makes a joke about it. She makes a joke about it in the last hearing. So what the fuck is going on here? What the fuck is going on here? This is bizarre.
Given that we have an April 16th trial date and I have nothing as far as any sort of reports or notice of experts or testing or anything really at all, I'd appreciate being able to get that, review that, or at least see it, prior to the day we're impaneling.
So, Judge, since even though they're not obligated to share this stuff, it'd be really cool, Bev, if you'd hook it up and order them to share it, even though they're not obligated by the law to do so. You want to help me out? I'm curious if she does. I'm very, very curious if she ends up doing so. Fascinating.
Right. What do you say, counsel?
Your Honor, as you know, we do not owe them any reciprocal discovery until they file a certificate.
Right.
I mean, we have received hundreds of pages of documents. I mean, 4 days ago, we received like 400 pages of documents we haven't gone through. Counsel just handed us a thumb drive with, I don't know what's on this thumb drive. We have to go through that. So we haven't given any reciprocal discovery because we are not obligated to do so.
Do you intend to call experts
Yes.
in areas other than DNA?
I'm going to have to defer to Mr. Jackson, who is on Zoom.
All right, but counsel to arguing these motions was to be present here in court today, right?
Your Honor, if I can be heard for just a second on that issue, Mr. Lally made it very clear that given the fact that he was not in compliance with his discovery obligations, that this motion was not to be heard today. So this is sort of coming out of nowhere.
No, hold on.
Wow.
So Mr. Lally doesn't decide what motions were to be argued?
Today. So not in compliance with his discovery obligations, but this motion was not to be heard today. So this is sort of coming out of nowhere.
Hold on.
Okay, so Alan Jackson's like, I didn't even know that this is what we were going to be talking about today. And so Auntie Bev gets defensive here.
So Mr. Lally doesn't decide what motions were to be argued. Today was for all non-evidentiary pretrial motions were to be argued. This was filed timely. This was on for today. If you feel that you cannot argue it, that's a different story.
Wow.
So you are muted. All right. Mr. Jackson, you're muted.
I don't know how I got muted. Yes, we are intending to call experts, and there are going to be experts that are in areas other than DNA as well. But we haven't provided discovery because we don't even know what the 400 pages that we just, or 500 pages that we just got 3 or 4 days ago include, nor the discovery that was handed to us this morning. As soon as the Commonwealth gets finished with their compliance obligations, we will then comply with our discovery obligations. We have every intention of doing so, and we're fully prepared to do so. We're waiting on them.
So once you get it from the Commonwealth, you can have it in the matter of a day or so, other than the DNA?
Oh, I don't know if I can do it in a day, but
Well,
once we have full
You do know, if you're calling witnesses, you know who you're calling, correct?
I have an idea who I'm calling, yes.
All right, and you've engaged experts, so you've been working with experts, so you should have all that information ready to disclose, correct?
We're in the process of getting those decisions finalized, yes, but some of them are going to be predicated on what the Commonwealth discovery and the totality of the Commonwealth discovery looks like. I mean, that's their obligation.
No, I understand.
All right, people.
But you will be calling witnesses, and you will be
If
calling
you step
expert
back,
witnesses.
if you step back and use your eyes for a moment here, because I saw some comments before when we first started streaming this. I saw some comments before, and they were saying stuff like Judge Bev was stalling. That's not what I'm seeing. Now, maybe I'm reading this wrong, but Judge Bev seems to be wanting to move this along to trial. She wants this wheel turning. And she's like straight up, like she cuts Alan Jackson off and she says, hey, if you're not ready to argue, this is what the motions, this is what this was, what was scheduled for us to talk about today. And if you aren't ready to argue this, well, then that's just what that is. But she absolutely seems to be wanting to move this along to trial. She keeps bringing up trial is 3 weeks from today. Or do you have experts that you're going to bring up to the stand? Like, they don't have their case ready. Remember something. Karen Reed waived her right to a speedy trial. She waived her right, and they have filed motions to try to delay this. The defense has, not the Commonwealth. The defense has filed motions to delay because they need time to present their case. Because you've got to understand what a speed bump the findings of the federal investigation is. We're talking about 3,100 pages of documents, and we've got, 1.3 gigabytes of data to go over. So I don't know how much that is, but it sounds like a lot, the way that Alan Jackson presented this. So it sounds to me like the defense needs more time, and they were really hanging on the federal findings, the federal investigation findings to present their defense for Karen Reed. That seems to be their strategy. And if they can get the case dismissed and get this person, get the Norfolk County prosecutor's office, the DA's office recused, get them disqualified from the case, well, then, I mean, that's a win. So, but what's right now, we're at a place where the defense does not sound like they're ready to go to trial yet. And Judge Bev seems to just be going, hey, this is happening. This train is moving. So you better get on board. That's kind of the vibe I'm getting from Judge Bev in this hearing, the overall Judge Bev vibe.
Absolutely.
All right. What is your estimate as to how long this case will take to try?
I assume if the if the Commonwealth case, I'm just throwing a dart at
What a
dartboard, but
question.
based on what I know, if the Commonwealth case takes 3 to 4 weeks, I think our case would probably take 2 weeks.
Okay. All right.
Now you know that he's trying to like give himself time. That sounds to me. Now I'm not, I'm not a lawyer. I'm not a lawyer, but I'm telling you, it sounds to me, I mean, he still sounds extremely confident. He's like, if the Commonwealth has, if it's going to take them 3 to 4 weeks to present their case, it's going to take us 2 to shoot it down. That's it. It's going to take us 2 to shoot it down. So that's interesting.
All right. Mr. Lally, I suggest that you get that information as soon as possible. It could be that I strike it, but I would hear from the defense on that as well. But at least find out if they're able to do the testing.
Yeah, sure.
All right. All right. Thank you. You have your next date. We'll see you then.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, Mr. Clerk.
See, that's not going to happen. That's not going to happen. I'll tell you that right now. That's not going to happen. We're gonna look in on Tom CPU in a second here. So here you are saying that you predict that Karen Read cuts a deal. There's no way. First of all, you don't hire a defense team and plead not guilty unless you're ready to go to trial. Like, unless you're ready to do that. Straight up. But the defense is doing their job. I mean, she has a great defense team. So what they're doing is simply trying to avoid trial if they can. I think they have all the grounds in the world to do so. This investigation, the way it was conducted is absolutely a violation of Karen Read's rights. Even if these mistakes were negligent. Because the fact is, it boils down to this, okay? It boils down to the fact that in the eyes of the law, she is innocent until proven guilty. That is just how it works. She is innocent until proven guilty. And if she is an innocent woman, which she is in the eyes of the law currently, right now, Karen Read is absolutely an innocent woman. If that's the case, well, then that makes her a grieving girlfriend of a fallen police officer. Do you see what I'm saying? And everything that I'm seeing Alan Jackson and David Yannetti doing for Karen Read and the rest of her legal team, what they're doing for Karen Read is exactly what they should be doing. Is that they're presenting her defense exactly as they would an innocent woman's defense. I mean, that's the thing. If she goes into court, and all they do is just throw up some smoke and mirrors, Alan Jackson does his charisma thing, David Yannetti goes up there and just dazzles with his words and throw up smoke and mirrors and just poke holes in the prosecution's case, which is a very easy thing to do. It's very easy for them to do this. But if they do that, what's going to happen is the public is going to look at Karen Read as the woman who got away with killing her boyfriend, who's a cop. That's the way everyone is going to look at her. If all they do is that, it's not enough. It's not enough for Karen Read to just simply lay down and say, okay, well, this is easy. The prosecution has no case, and we'll just prove that the prosecution has no case, which is something that they'll do if there's no other way to do it. But the problem is that the reason why Karen Read, why the prosecution has no case against Karen Read, the reason why that is because of how the prosecution, how the investigators in charge of investigating John O'Keefe's death, how they conducted their investigation. And it's shady as hell. Make no mistake. The people directly responsible for costing John O'Keefe justice are the investigators, because they failed. They failed to collect evidence in your basic in the basic way you're supposed to collect evidence if you're in law enforcement, in every aspect of this case. There's nothing documented. The statements aren't even signed. They're saying that the evidence, the notes that they took to get the statements no longer exists. They're saying that the device that took the pictures of the crime scene photographs no longer exists. They're saying the metadata that's in that device no longer exists. I mean, the prosecution, they collected blood samples with red Solo cups. They blew away, they blew all over the evidence with a leaf blower. You've got blood found in this snow after a blizzard, and it's on top of the snow. Explain that shit to me. I mean, you've got microscopic pieces of the clothing, microscopic pieces of John's clothes, of the taillight in John's clothing, and we've got pictures of John O'Keefe's clothing laying on the hospital floor just as he's being pronounced dead, and it's not logged into evidence for another 3 weeks after that. And they're trying to say that the microscopic pieces of taillight in his clothing are going to hold up somehow. That the defense isn't going to be able to just destroy that with, like, what juror is going to be sitting there going, wait, they're not going to go 3 weeks? What? And yes, Cherry, missing parts of his clothes. Where's his other shoe? His other shoe's still gone. It's crazy. This whole case is blowing my mind. I don't think Tom is live anymore. Yeah, he's done. All right, hold on. Let me catch what this last part that he's got here. Yeah, I didn't mute him. He's muted for some reason. Yeah, I don't know why he doesn't have sound right now. I mean, he's not live. He ended his live. This is just... No, this is where I saw them talking to the reporters. This is just... It's about to happen right now. This is before that. Let me see if maybe it's me. No, it's Tom. Okay, thank you, Heather Donahue. interested in what Vinny says. Thank you. I'll check that out. I hope he doesn't get mad at me for stream sniping him, but I'm totally going to stream snipe him. But I'm going to share out his link, though, you know. I don't see Grant, which is good.
Karen, I like your shoes. Comes her dad.
Did Karen say love you, Tom? That's sweet, man.
What's up, bud?
I like your shoes. You gotta love Tom, man. You gotta love Tom.
I mean, we're 21 days from the trial. Do you expect that's going to happen? Yeah, the judge originally said.
I just don't know. I believe if it goes to trial, I think there is enough information that's been put forward and argued by Attorney Jackson that the grand jury at the state level perhaps was not provided with all of the information it should have been, perhaps not as forthcoming in prosecution. So I think to the extent that that informs Judge Canoni's decision about whether or not to dismiss this case based on Attorney Jackson's forward, I think that is meritorious, truly do. But we all know the case. If we go to trial, we will prevail. There will be experts, informed experts. And I always keep thinking of this. I remember some of the letters that were produced in the court. One of them in particular that came, I'm going to paraphrase it, or maybe off the general counsel for the U.S. attorneys responding here to Norfolk County, essentially saying that the acting U.S. attorney from Massachusetts is a very different opinion of this case than what is put forth by the Commonwealth here. And I look upon that as the overarching fact that keeps me going. That somebody at that high level, highest level, federal authorities, based on their investigation that is still ongoing, my understanding, potentially or allegedly believes.
I love this gentleman because he's applying common sense. He's basically saying that now this is Karen Read's father, and he's basically saying that he has faith. Basically, I mean, because he remembers in the letters that the U.S. attorney has a very different opinion as the Commonwealth on the case against Karen Read. So he's holding on to that. And he knows that the case is still, that the investigation is still ongoing. So Karen Read's father is absolutely holding on to the hope based on the fact that he knows that the U.S. attorney has a different opinion as to the case against Karen Read than the Commonwealth does.
This was in that letter in early August. And you know what I'm speaking of. You have it. It's the second paragraph, essentially saying Joshua Levy has a very different opinion of the circumstances in this case. And it is essential that his investigation go on. So I'm a reasonable individual. And when I look at that and I digest that and all of the evidence that's been put forward by Karen's.
Now, I got to address the comment here. And I know it's coming from a very wonderful place. So I'm not jabbing at you, I promise. You're saying, hurry up, Mr. Levy, please. See, I've come to the conclusion after following so many cases that justice, true justice, takes time. Now, here's the thing. if Karen Reed was guilty of this crime, I would have felt a lot more comfortable if the Massachusetts State Police and the investigators tasked with the responsibility of getting John O'Keefe justice had conducted a sound and thorough investigation. So, you know, it's important that, you know, I like I said, I would be singing a very different tune up here. I would not be saying and hashtagging free Karen Reed if I believed that the interest of justice ever took place from anyone from the Norfolk County DA's office down to the Massachusetts State Police. I don't believe that anyone made any decisions in regards to the investigation into John O'Keefe that was in the interest of justice. I don't think they made any decisions in the interest of justice when it comes to this. So, you know, I don't want this to go to trial, but at the same time, if this has to go to trial while they conduct their investigation, but I just don't see it happening. You know, I don't see it happening. I still, I mean, trial is 3 weeks away. It's set, and Judge Bev seems on fire about it, right? But the thing is, you know, it's 3 weeks away. A lot can happen. A lot can happen. So we'll see. But I think this is going to go to trial at this point. I really do. I hope it doesn't, but I think it will. But I want, overall, I want the people who should have gotten John O'Keefe justice to be held accountable for whatever their role was in costing him justice, whether it be negligence, whether it be corruption, whatever it takes. You know, whatever these federal findings can prove. So I really hope that happens because John O'Keefe absolutely deserves justice. And if he's cost justice, and if this gentleman here that we're seeing on my screen is cost justice along with his loved ones, then you know, somebody, we have to, if we're going to settle for something, it has to at least be that those who cost him justice are held accountable. So
The Legends defense team, I'm very encouraged.
Bill,
Did you see-
why did the judge said that she was expecting a motion for egregious prosecutor misconduct? Why wasn't that filed?
Gross government misconduct, governmental misconduct. My sense is, as you heard, it was strategic, and you can make of that what you like. But I think you have a pretty good understanding of what that means from our standpoint. It's not that it wasn't substantive, not that it wasn't meritorious. That's my understanding. I don't know what it contained, but from what I was able to glean, just the hearings, it was meritorious, but it was a strategic decision.
How about this? You know, it looks like it'll be a 6-week trial from what we can tell. What do you think about that? What do you make the 6 weeks?
It's been a hell. 26 months, it's been a hell. And if we have to go to trial, we will clear this up.
I mean, that's what I don't find. That's what I find so weird, because the prosecution wants this to go to trial so bad. Auntie Bev wants this to go to trial so bad. But the thing is like the things that are going to be shown and on the record at trial are going to be damning to people. Not just Karen Reed, but it's going to be damning to the prosecution. It's going to be damning to people in the Norfolk County DA's office, to people in the Canton Police Department, to people in the Massachusetts State Police Department. There's going to be so many people that are going to have so much egg on their face when the defense presents their case to exonerate Karen Reed. That's what I find fascinating. Why do they want this to go to trial? Captain Skid Marks, member for 1 month. Welcome to Logic. This is bizarre to me.
He's got a great defense team, and we've got the facts. We have the facts. We have the truth. And so I'm not. Listen, I want this to end. No father should have to go through this. For a factually innocent child, I want this to end. If it has to end through the court proceeding, then it will. But I'm hopeful this Honorable Judge Cannoni will see the merits for the dismissal argument and dismiss this case.
You have a sense that that's what she will do, or
I have no sense. I have no sense. That's her decision making. But I'm hopeful.
Wow.
She's an honorable judge.
Let's hear that one more time.
But I'm hopeful this Honorable Judge Cannoni will see the merits for the dismissal argument and dismiss this case.
you have a sense that that's what she will do, or
I have no sense.
Now, you heard Karen Reed's father saying, I'm hopeful that Judge Cannoni will do the right thing. And this reporter asked, do you have a sense that she'll do that? And he's like, I have no sense that she'll do that, but I'm hopeful. And I think that that's incredible. And beautifully said. What am I looking at here, Cherry? This is okay. Interesting. What? Okay. Okay, I'm going to read this in just a second. Thank you, Cherry. Was this just filed? Was this motion just filed, Cherry? Sorry, guys. I'm waiting for a response from Cherry. Yes? Okay. All right. Give me a second. Let's finish up Mr. Reed's interview here.
I have no sense. That's within her decision making. But I'm hopeful. I think she's an honorable judge, and I hope she sees this case and its limitations in terms of what's going to go forward. So thank you all. I appreciate all your help. Thank you.
Thank you, Mr. Reed.
That's amazing.
Good job, bud. Isn't that awesome? Isn't that just such a nice guy?
So nice. I know, right?
Yeah.
What a nice family.
Oh my God, yes.
Breaks my heart, Tom.
Yep, it does. But that's why we're here.
You know, I'm gonna cry.
I know. It's okay. It's okay.
Oh,
That's
God,
why we're
it's
here.
sad. Hi.
Okay?
I know, I know. Mm. Sad.
She knows.
Yo.
Yeah, absolutely.
Yeah, I'll wait for you. You see the new motion for Congo just filed?
No.
Can we talk about for a second how sweet Tom and his lady are, bro? Like, can we talk about Tom is just like the sweetest, nicest guy ever, dude. Like, ever. I love it. I absolutely love it. All right, so they're going to talk about this motion. Let's see what this says. Let's see what they say about this motion.
Protesting.
No,
Even mentioned
I don't wanna-
pets with free Karen Reed shirts. I'm going to Nathan.
Wait,
the motion was I just posted the screenshot. Was the motion released? I Trevor was talking about it on that thing.
They want. I gotta drive up to Hooksett, New Hampshire to go to work, so I'm gonna rewatch it in the quiet and drive.
I can understand the gear inside, but
Huh?
they're gonna try to.
So what are they?
Yeah, I'll get one of that. Yeah, no. I forgot. Forgot about that. Scott, where's your brother? He said you give me a ride home.
All right. Is this gonna piss me off? Is this gonna piss me off? This motion that I'm about to read. So the Commonwealth just filed a motion. Let me go ahead and share it with you guys real quick. And thank you, Cherry. So 4 pages here. Commonwealth filed a motion. Says here, Commonwealth's motion for a buffer zone surrounding Norfolk Superior Court and request for order prohibiting signs or clothing in favor of either party or law enforcement. Wow. Okay. Now I got to tell you guys, I find that shit fucking infuriating. Like if you cannot see how this is absolutely an attempt to violate the First Amendment rights of the citizens of that community on a mass level, if you can't see that as that, I haven't even gone into it yet. Just the title alone is absolutely that. These people should be allowed to protest. Those court steps belong to them over anyone else. Those court steps belong to them. The Commonwealth of Massachusetts, okay? The prosecution, the Norfolk County DA's office represents in court the people of the Commonwealth. The people of the Commonwealth are exactly that, those people standing out on those steps, standing out on the court, in front of the doors of the courthouse, wherever the fuck they want, on the property of that courthouse, because their taxes pay for that courthouse. Their taxes pay for the salary that pays Lolly to file that motion. I'm going to say that one more time. Those people who stand out on the steps of that courthouse, their taxes pay for that courthouse, and their taxes pay for the asshole who filed this ballsy motion to have a paycheck, put a roof over his head, provides the car he drives, provides the food on his table. You guys want me to read this, or you want me to go over to Vinny and check out Vinny? We can do that. I meant to do that before. Here, I'll share the link. Here's the link to the motion. Oh, it's too long. Sorry. Oh, you can't even click on it. All right. All right. Let me just find Vinny. You guys want to watch Vinny? All right. Let's check out Vinny. Let's do that. Everybody's like, Vinny, Vinny, Vinny.
One thing only, the truth. The truth.
Facts.
To come out inside the courtroom. Now, there's some troubling facts that are taking place here in terms of the investigation and the way things have progressed here. Is for some reason, and again, that's debated as well, there's been an independent federal investigation of the investigators in this case, in an ongoing murder case. That's unusual. Very unusual. I mean, the only times we've seen that sometimes are in cases that are racially charged or allegations of something along those lines. And I've seen those cases where the feds have come in and said, oh, is there a civil rights violation here? We're investigating that. But this is a little different. Like, this is a very ordinary.
All right, so we're going to be a little behind. But listen, take a second real quick. Click over onto Vinny. Give the video a like, his live stream a like. Make sure to subscribe to Vinnie Politan. This is his YouTube channel. I just dropped the link to this live that I'm streaming right here, and I pinned it. So click on that and give it a like for me. Just take a second and do that.
Murder case, right? When I say ordinary, I mean there was no, like, we've had cases like this before. Boyfriend, girlfriend, spouses with allegations of murder. And never have I seen a federal investigation inserted in this. The only time I've seen the feds get involved in cases, which is like in like Derek Chauvin and the George Floyd case, Ahmaud Arbery, the case in Georgia, and other cases around the country, they're usually racially charged, and there's some pressure on the feds to come in and take a look at the local police to see if they were investigating things properly. But never in a case like this have I seen that. So where exactly are we in all of this?
So Cherry just dropped the link.
Well, I don't want to play for you.
Cherry just dropped the link to the motion that that the Commonwealth just filed. We'll still go over that. Let's watch Vinny for a little bit first, and then we'll go over that. We'll be here for a minute, folks. I'll even make a second pot of coffee if you guys want.
For you, but before I get to that, there's a moment inside. Let me see if I can find it. Because I said this is unlike any case I've ever covered. And I've covered a trial before in that same courthouse in Dedham, Massachusetts.
Now, you got to understand, Vinny is, when he says he just wants justice, that's all we want. You know what I'm saying? He's not on anybody's side. He's just asking the right questions. That's all. That's all I ask of anybody who covers this case. Ask the right questions. Ask the right questions and use your common sense and listen to people who know what the fuck they're talking about.
And let's see, is that this one? Let's see. Okay. And that was, so I'm going to show you this. I'm going to remove it because this moment was unlike any moment I've ever seen in a courtroom. And like I said, I've been in this courtroom. And again, she's been accused of murdering a police officer. Right? So she's an accused cop killer. That's who Karen Read is.
We see Vinny do this a lot. It's just interesting.
Right? They're not saying it's an accident. They're saying this is on purpose. And I've never seen someone like that have this level of support and this level of what's happening at the courthouse. Like, these supporters are showing up. And watch what happened when she walked into the courtroom at one of her hearings.
Vinny's like, dude, am I in the fucking Twilight Zone right now? Like, I've never seen that shit. She's an accused cop killer, and more people are supporting her rather than condemning her as a cop. I've never seen this before. This is a guy who works for a station called Court TV who will absolutely spin a narrative of someone's guilt or innocence. Absolutely. And normally it's someone's guilt. Sorry, but it's true. So here he is going, well, wait a minute. And that's the thing. It's you're usually right. The thing is normally the prosecution, for the most part, as far as the majority of cases go, of course, the person charged and going to trial is likely guilty. Statistically speaking, of course, that happens a lot. It's because the prosecution tends to actually have a strong, airtight case. They have to know that they are going to be able to present to a jury and prove to a jury beyond a reasonable doubt that the person on trial is guilty. They have to be able to prove it airtight. No mistakes, no holes, nothing. And normally they won't even take a case to trial unless they feel they can do that. The prosecution has nothing that's solid. So Vinny's looking at this like, what is going on here? I mean, it's fascinating.
Hold on a second. Let me fix my audio stuff. One moment. Need a flashlight for this one. I cannot hear what's going on in the air here. There we go.
Come on, Vinny.
Here's a shut off here. But applause. Applause walking into a courtroom? Applause going into a courtroom for someone accused of murder.
Now, here's the thing, Vinny, is she's not getting applause for killing a cop. She's not getting applause because people think that she's innocent. She's getting applause because not only is she innocent, but she's fighting back. That is what her defense team's strategy seems to be. That's where the applause is coming from. Not just that she's innocent. That's not what these people believe. Not just that she's innocent, but they respect her because she's also appearing to be fighting back. That's where the applause comes from.
Completely unusual. Unlike any case I've ever seen in my decades at Court TV, covering cases around the country. Around the country. I've never seen support for someone accused of what she's accused of. That makes this so different. And the aggressive nature of the defense in pointing fingers at specific people before the trial. Before the trial. Sometimes, the defense kind of whips this stuff out during the course of the trial, trying to put the prosecution on their heels. But that's not where they are in this. They're doing it ahead of time. It's just not done.
Right. Exactly.
It's just not done that way. Again, makes this so different.
Vinny's wheels are turning like where mine were 2 months ago. Like right now, the same wheels that are turning in Vinny's head are what are the ones that were turning in my head 2 months ago. What in the hell is going on here? What is happening? Why is this even going to trial? This is the craziest thing in the world.
Different. All right. Give me 1 second because I have to. It's just not done. But that whips this stuff out during the course of the trial.
And this point is everything.
Prosecution on their heels. But that's not where they are in this. They're doing it ahead of time.
Right.
It's just not done.
Right. It never happens before trial.
It's just not done that way.
You guys remember me saying this months ago. I said it months ago. I said it when I had Turtle Boy up here the first time. I said, dude, like what I find really weird here is that the defense seems to be presenting a case against the investigators here. The defense seems to be the ones providing all the evidence, and the prosecution isn't providing anything. I've never seen that before. So it's fascinating. It's absolutely fascinating to see this dude. I mean, it's weird that it's happening so many months later, but I love that it's happening nevertheless. I am grateful to see Vinnie Politan just being like, this is the craziest thing in the world, because it absolutely is. Before you think, oh, well, this is just all wacky because you've got some guy who calls himself Turtle Boy and he's making noise over here. And then you've got this going on. And then he's stirring up all these people. And it's easy to see it that way on the surface. But when you really look at everything, you're like, okay, I get it now. These people aren't just out there just gathering and being assholes just to be assholes. These are not bad people. They would not criticize the O'Keefe family without feeling as though they had strong reason to criticize them. This is insane. I've never seen anything like this. Yeah, happy belated, Paul. Good to see you, buddy.
Again, makes this so different. All right, give me 1 second because I have to be able to monitor the sound, and I'm just trying to find why this is not working for me. 1 second. I'll be right back. Oh, there it is. I got it. Hold your ears. There you go. Whoa, there we go. Now the sound is at least happening. I had to do another podcast this morning. All right. Now let's take a listen, because I have tried to outline what they're alleging here, but they're actually alleging it on the steps of the courthouse. Take a listen.
That's what we're trying to figure out. That's exactly what we're trying to figure out.
Who do you think it is?
Well, certainly the Massachusetts State Police is involved. There are people that were in that house that are involved. Brian Albert is involved. Jennifer McCabe is involved. The rest of the folks that were in that house, there's some level of involvement by every one of them.
It feels we're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. Just feels like no one else wants it.
Yeah, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
This game is over. We know what happened inside the house. We just don't know who struck the fatal blow. And the prosecution, it doesn't seem to want to get to the bottom of it. We're trying to.
On a Friday night in January 2022, Karen Reed and her boyfriend, Boston police officer John O'Keefe, joined friends for drinks.
We were happy, having fun, laughing, just very normal.
Did you ever feel you were overserved that night, as they say?
No.
When she woke early, John wasn't there. She went out searching, and 6 a.m. found him lying unresponsive in the snow and bitter cold in front of the home where she dropped him.
His eyes were swollen shut. He had blood dripping out of his nose.
She blurted out her thoughts as first responders arrived. Did you say, I wonder if I hit him? Did I kill him?
I said, could I have hit him?
What does the defense believe actually happened to John after Karen dropped him off?
I think he walked into the house. I think he was confronted, was likely brought down.
Sorry, guys. I got to do it for my man, Grandmaster Sid. It's got to happen.
I think we got a super dad. Super dad. I think we got a super dad. Super dad. Super dad. Super dad. Dad, 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 dad. I think we got a super dad. I think we got.
Thank you, Grandmaster Sid Sophos. I appreciate you, buddy.
Brought down to the basement. I think that confrontation got physical, and he was beaten. He was beaten to a point of unconsciousness. He's got some defensive wound bruises on the backs of his hand. He's got this massive laceration on the back of his head, a big giant gash, about 2.5 inches, exactly lateral, going from left to right. 2 black eyes, cut over his right eye, cut over his nose. This was a cover-up that John was murdered inside that house.
Okay, so those are the...
I got 955 people watching on Twitter. So thank you, Twitter, guys. Appreciate all you guys on Twitter. You guys are fantastic.
The allegations. Really specific, like naming people. Naming people that are responsible, according to the defense.
Well, he's
named.
named.
Put this all in perspective. You put the piece.
He's named people responsible for the cover-up.
Just together, they're alleging some level of coordination between the people in the house, the responders who were investigating, and when you follow it all the way through, there's the Google search that they're saying was done at 2:30.
You know how you know they're all in on something? They all butt dialed each other. Come on, man.
But then when you look at some of the forensics in the case, the taillight, DNA, they're going to allege that it's actually planted evidence.
They are alleging it.
Not like misinterpreted, not like overlooked. Now they didn't know that some of this evidence that's being used against Karen Read in this prosecution was actually planted. So the level of the coordination is a massive cover-up frame of Karen Read. And that's what they're saying. So this is going to play out as the case against Karen Read is playing out, because it'll play out through the cross-examination of witnesses. The defense often makes their case. In most cases, they usually don't have any evidence, but they try to make their case and put it together while they're cross-examining the state's witnesses as the state is trying to put their case together. And again, it gets back to my headline. This is a trial you must see.
Yeah. Yeah.
Many of the cases on court TV, the defense is, they can't prove it. The evidence just isn't there.
Right.
Right. And that's because of the way our system's set up with the burden of proof.
Right.
And that's a legitimate defense, but it's not a search for the truth by both sides.
Right. I love that Vinnie Politan is acknowledging this fact. I love it, because I've also been saying this from the beginning. All the defense has to do is just prove doubt. That's it. They just have to provide doubt, and yet they're not. They seem to be on the search for justice. That is very telling. So Vinnie Politan stating this right here is a big step forward. It's a big step forward.
Right? Like here, both sides say, we know what happened. We're going to show you in court what happened. The evidence is going to show you what happened here. Not they can't prove it. No, we're going to show you what really happened here. That's
right.
Again, what makes this case so different. The public
Right.
reaction and the scene at the courthouse. Every time.
Vinny's fascinated.
Dozens and dozens of people with signs, etc., at pretrial hearings, not even at the trial.
Right.
Like they're having a motion.
Wow.
Like a motion for whatever. Like these things in most cases are very ordinary courtroom appearances. And so the lawyers show up, the defendant shows up, no one's in the gallery. Sometimes if it's a big case, the news is there. Sometimes they're not even there. This one, again, is different. And I don't know why the troll mafia believes that I have a stake in all of this. Why do you support this egregious level? I don't support witness intimidation. Like, I don't.
Right.
What I do is report on everything that's happening.
There you go. Get her, Vinny.
And open the microphones to all sides of every case, like I always do.
See, Vinny probably doesn't know, and that's okay. But Vinny probably doesn't know that she currently is charged with felony witness intimidation. And here she is super chatting Vinny because she must be heard. Kate Peter must be heard. Here she is super chatting Vinny and stating that he supports and accusing him like it's like it's an accusation of supporting witness intimidation, even though she is currently charged with felony witness intimidation right now. But I don't think Vinny knows that. He might know it, but I don't think he does.
It's just that it's rare that the defense speaks. They spoke to me, they spoke to ABC, they spoke to NBC. Prosecutors speak through their charging documents. I mean, they rarely talk once the case has been indicted, because ethically in most jurisdictions, and every jurisdiction has slightly different rules. In most
I
jurisdictions,
mean, how awesome would that have been if Vinny would have been like, aren't you charged currently with witness intimidation yourself? What are you talking about? But he can't do that. Like, he still represents Court TV, you know, like he's definitely, this is the thing though. This is what I'm loving about Vinny right now is he's not saying Karen Read is innocent. At no point do you hear Vinny even allude to Karen Read being innocent. Make no mistake about that. But he is asking the right questions. He is saying, dude, the defense not only plans on poking holes in the prosecution's case, which is just what their job is to do. They plan on getting justice. That's their whole defense, is they're actually the ones getting justice for the victim. So he's acknowledging that this is the defense's strategy. That's all he's saying. He's not saying that's the case and that's what's happening. He's saying this is the defense's strategy, and he's never seen that before. That's all he's doing, is acknowledging the fact that this is fucking unheard of. And so that's very telling, though, because the thing is nobody else on Court TV has done this yet. Nobody else on Court TV has done this yet. So this is very, very fascinating. So, like, I've got this deep-rooted respect for Vinny right now, because Court TV seems to be spinning a certain narrative, and he's just not on board with it.
Jurisdictions, prosecutors don't speak. They'll speak in a very limited fashion after the trial. Sometimes they'll make an announcement when there's an arrest or charges, and they'll talk about what those charges are. But they're sort of hamstrung by what they can say. And in this case, and in most cases, the defense is not. And in this case, the defense spoke a lot. The prosecution also spoke, addressing all of these issues and accusing the defense and indicting Turtle Boy for witness intimidation.
There it goes.
For the protests and the allegations and the bullhorns and the showing up at the house. And the man who was leading the protests in this case is now being prosecuted by the same office that's prosecuting Karen Read, which again is another reason why you must watch this case. I mean, there's like three outcomes here. There's three potential outcomes. One is she's convicted and it's over. Like, she's convicted, like she'll appeal, etc. But like, okay, she's convicted. The jury has spoken. They believe exactly what the prosecution has alleged here. Now you can have a not guilty, which means 12 people agreed prosecutors didn't prove the case beyond a reasonable doubt, which then sort of opens the door to, well, if they didn't believe this happened, what do they believe? If the jury speaks afterwards, which they're permitted to do, are they going to tell us that they believe the defense theory, or are they going to say, well, there just wasn't enough? I don't know. We thought the defense theory was a strong possibility or a reasonable alternative explanation for what happened.
And if that's the case right there, they have to acquit. They have to. If that's the case, they have to acquit. See, Vinny's seeing this for what it is. The bottom line here, it doesn't fucking matter. Let's just say the jury just doesn't believe it, right? Let's just say the jury just simply does not fucking believe that that there was a conspiracy and that these people all colluded. Let's just say that they don't believe that. But the problem is that they're forced to consider it a possibility. There's no way around them having to consider it as a possibility. And there's no way to absolutely dismiss it, because there's too much pointing. And it starts with how the investigation was conducted in the first place. So you look at this, it doesn't matter. If what you're gonna get, worst case scenario, if you're team Karen Read, what you're gonna get, worst case scenario, is the jurors deliberating and going, I don't know. I don't know what to believe. I don't know if there's a conspiracy. I know that investigation was fucked up, but I don't know. So, I mean, well, if we're all sitting here going, I don't know, well, we can't convict her. It just boils down to that. That's what it all boils down to, is once a jury deliberates, there's no fucking way on God's green earth that there will be a conviction of Karen Read by a jury of her peers. There's just no fucking way.
Happened. And that's why they voted not guilty. Or you could have a hung jury where the jury can't agree. Like these attorneys can't agree. Like the public so far can't agree as to what happened here. So, and I don't know, like if you watch my show, I say every time, because I know of the emotions and the passion that people have on both sides of this case. I'm just in search of the truth. And to me, the more we hear, the better we have an opportunity to understand the truth in a case. Now, inside a courtroom, there are limitations by the rules of evidence, hearsay, and other rules that come up during the course of a case. So the jury doesn't get to see and hear everything, but the public certainly can and can consider everything.
Right.
And what's happening in this case is one of two things. Well, it could be three things, because, you know, it could be that she did it on purpose. It could be that she'd been drinking. She didn't even realize that she did it. And it was an accident that may in fact be criminal in nature, right? Because accidents can be criminal.
Well,
that's the
yeah, if she
allegation
was
against Alec Baldwin.
sure, if she was drunk, you know, then of course it makes it in criminal. It makes it of criminal nature. Absolutely, if she was drunk, and I believe she was drunk. But the problem is that there's nothing that solidifies the theory that she hit him with the car. There's just nothing.
The same thing. Some level of manslaughter. Those two results can happen, or what happened here is that she was wrongfully accused. Our system is set up so that guilty people go free before one innocent person is convicted. So the deck is stacked for defendants in our system of justice. It just is. And you learn that when you're a prosecutor. Now, I'll just address one more part of. Oh wait, here we go. We have more. One more part of the.
Vinny's not used to this. Vinny's not used to having a channel. He needs some moderators. He's not used to the trolls, and he's trying to be nice. And I'm going to take a stab in the dark, and I see Vinny being the kind of guy who, if he wasn't a television personality, would be very quick to tell you to go fuck yourself. I'm just going to take that wild guess. It's just speculation, folks. It's just speculation, but I feel like Vinny's just playing it cool. You got these morons in the chat that are like, "Oh, you're taking sides." Shut the fuck up.
The complications of this case, right? Because the defense is saying they want justice for John O'Keefe. But from their perspective, justice for John O'Keefe means Karen Read didn't do it, someone else did it. And they believe the truth is somewhere else. It's not what prosecutors think. It's not what any of the investigators who took a look at this case believe. They believe justice for John O'Keefe is Karen Reed being convicted. But what justice really is the truth, which is, and again, this is the difference between the prosecution and the defense in every case. The ethical obligation of prosecutors is justice seeking the truth. The ethical obligation of every defense attorney is to protect their client. And I've talked about this many, many, many times in different contexts. But if you apply that,
Vinny's out here spitting fucking facts. That's exactly the point behind the motion to disqualify the Norfolk County DA's office from this case. Because there's nothing to indicate from the investigation to the prosecution, there's nothing to indicate that the interest was justice for this victim. Nothing. So that's the issue. That's the problem. There does not seem to be any interest to get justice for John O'Keefe due to how sloppy this investigation was, how railroaded this investigation was. That is not getting justice. That is not seeking the truth. The truth. Justice can only lie in the truth. It can only come from the truth. The truth is the foundation of justice. There's no substituting it. There's no going around it. The truth is the foundation of justice. And that is the Commonwealth of Massachusetts' responsibility. The Norfolk County DA's office has the responsibility. They're tasked, charged with the responsibility of getting John O'Keefe justice. And they have failed him.
That to this case, you apply that to this case. This DA, right, who's been attacked, his ethical obligation is not to just win a case. His ethical obligation is to the truth, whatever it is and wherever it leads him. And he believes, and I saw him make his announcement, his video that he released, passionately believes that the truth to him is very obvious as to what happened here based upon all the evidence. And you need to have that firm belief to charge.
You really think so there, however you say your name? I don't know how to say your name. Tomislav Pejic? You think the FBI is going to just roll up and I don't know, man.
FBI, open up!
Oh, I hope I got you guys. I hope I got you.
Charge someone. That is your ethical obligation. Now, on the other side of the coin, the defense in this case and in every case has zero obligation to the truth. There's no ethical obligation to the truth. That is not their job. That's not their role. Our system could not work that
Which
way.
is what makes it strange. It is not the defense's ethical obligation to get to the truth, yet here they are appearing to be, their entire defensive strategy is getting to the truth. This is what makes this case so unusual. This is what makes the defense's strategy so unusual. We've never seen this before. Vinny has never seen this before. That the defense is not only, they're going above and beyond their duties here. They have no ethical obligation to get to the truth. All they ethically are bound by the law to do is to defend their client to the best of their abilities. Right? But what if getting to the truth is defending their client to the best of their abilities. Because that's fascinating when you think about it. Because here you are, when all they're ethically really obligated to do is to just prove that the defense is that the prosecution's strategy and theories are not solid. They're just they're nothing. Too many holes. That's it. Clubber. No. Come here. Come here real quick. Come here. Clubber, come here. Come here. Come here. Okay, whatever. So yeah, all they have to do is just prove that the prosecution just doesn't really have a case.
That way. It couldn't work.
No, Clubber does not pee in the house. Clubber does not pee in the house. If he has to go pee, he'll let me know, and then I'll just take him outside real quick. But nope, Clubber is totally potty trained.
Their job and ethical obligation is to do everything that is legal in the defense of their client and their client's interests. So you hear in courtrooms day in and day out around our country, and I've been listening to them for decades, arguments made by defense attorneys that not necessarily based in truth. And I've seen cases where they've explored different avenues of defenses, trying to find one that might resonate with the jury. Well, could have been this, could have been that, could have been this guy, could have been that guy. And they're permitted to do that under our system of justice. So the defense here is doing nothing wrong, but understand that ethically, as a lawyer who is a defense lawyer,
just now liking the video,
you can say the evidence shows this, and that.
Hey, make sure excuse me, make sure to click on the link that I have pinned and give this video a like, please, if you haven't already, and subscribe to Vinny. That would be great.
And that, even if in your heart of hearts you don't necessarily believe that. Now, in this case, they're saying they believe it, but you don't ethically have to. But a prosecutor does. And when a prosecutor goes after someone and the case is not based in fact or is motivated by something other than the truth, they get into trouble. Like the guy who went after the lacrosse players in North Carolina years ago. Got into big trouble because he was motivated by the politics of everything, trying to get reelected. Thought it'd be popular to go after the Duke lacrosse players, even though it wasn't the truth. And he was hiding evidence, etc. So, but those are some of the allegations here that are being made by this defense team. So I don't know what the truth is. I got to hear the evidence. I got to see the witnesses. I've got to see them cross-examined. I want to hear the experts. I want to know what the expert's background is. And I want to hear their explanations here, because you're going to have a battle of the experts when it comes to the medical examiners and the autopsy and the injuries on John O'Keefe, what they mean, what story they tell. You're going to have experts debating digital evidence from phones. So it 1 second, getting a text message. I have to check that. Okay.
The glare is streaming you right now.
So it's not clear, right? So it's not clear until you get inside of the courtroom, testify, get cross-examined, and then you make a judgment based upon, all right, how does that jive with the rest of the evidence? What evidence is sort of irrefutable? And I've posed this question right? When it comes to the truth in the case, right? Like what's the actual truth? Not can they prove it, but what is the truth of what actually happened? And I've asked this of my guests. I said, okay, you're a former prosecutor. I'm a former prosecutor. You could prosecute the people in the house, or you could prosecute Karen Read. Where's there more evidence? Which of those two roads is there more evidence? Which case, like if you wanted to pick one of those cases to try inside a courtroom, which one do you think you could win as a prosecutor? And I've answered that question on the air. I said the Karen Read case obviously is a stronger case for the prosecution. And if prosecutors went into the courtroom trying to prove this conspiracy, that case would be over in 2 minutes, because whoever you were charging in this conspiracy would point the finger at Karen Read and say, well, what about this evidence, that evidence, this? And that's like reasonable doubt in 5 seconds.
There you go. True, but it's the same thing the other way around, Vinny.
And
it's the same thing.
You could also argue that's, well, that's the way the case was investigated. You know, they didn't uncover everything. Okay, well, as it stands right now, based upon what's been made public so far, if you're looking at two files, one file is the case against the people in the house and all the investigators afterwards, and the other file is against Karen Read. Obviously, there's more evidence in the Karen Read file.
There is right now. There is right now, but the problem is all the evidence, Vinny, is that it's unreliable. None of the evidence is reliable. A. B, as it stands right now, you are correct. But the thing is we don't know what's in that 3,100-page document as far as the findings of the federal investigation into the investigation. That's the issue right there. Because more and more, that pile, that Karen Read pile, that defense pile is getting higher and higher and higher, little by little. So, and you wouldn't be talking about it the way that you are unless you saw that pile getting higher yourself.
Obviously. But now you got to try the case. And there are cases that we've covered on Court TV where there's you don't know. At the end of it, you just don't know what happened because of all the other.
So I'm hearing that Kate Peter is still super chatting Vinny, but see, that should tell you a lot. Because if Kate Peter is spending all this money just so Vinny will hear what she has to say, well, then that shows you something, doesn't it? Because shouldn't she be saving every cent she has for her defense right now? I feel like she should be saving every cent she has. Why is spending money so Vinny hears what you have to say so important? Well, especially when you're dealing with everything that you're dealing with. It says a lot. It kind of says that Turtle Boy probably has grounds to have this order because it's incredibly obsessive. Here you think it's more important that Vinny hears what you have to say in his own chat than your own defense against what you're being charged with, against a felony charge. Interesting.
Issues and reasonable doubt that exist, you don't know. Even if you believe you know, you don't actually know. And in the case Tara Grinstead, this woman from Ocilla, Georgia, was a teacher. She was a beauty pageant contestant, real nice woman, disappeared, never found. And years later, after a podcast, up and vanished, a guy named Bo Dukes comes forward and says, I helped get rid of the body. And it was Duke that did it. So it was Dukes and Duke, right? Ryan Duke and Bo Dukes. They weren't related, but they went to high school together.
Frank Dukes.
And prosecutors, based upon what Bo Dukes told them and the other evidence in the case, went after Ryan Duke. But when Ryan Duke was being tried, he got convicted of disposing of the body with Bo Dukes. But at the end of the day, the jury didn't know which one of them actually committed the ultimate crime. So no one was ever held responsible. I mean, is that possible here? I mean, it's a different case. But sometimes the evidence is just that way.
Who is this Iris person? Let me see.
That there's not enough on either road to prove it to a jury beyond a reasonable doubt, which is such a high standard, such a high burden.
Iris is a moron. So what does Iris say here? Anyone who believes the medical examiner reports was incomplete, it's crazy. You know how I know the medical examiner report was incomplete? Because the medical examination was incomplete. That's how I know. I'm going to shut you down right now. I know that the medical examination report was incomplete because the medical examination itself was incomplete. Why didn't they sample the wounds on John's arm? Why didn't they take samples of that? You got a police officer who died under suspicious circumstances. They never even took samples from his arm. Why?
Burden. But to believe that the defense theory is reasonable, you are going to have to believe that there is a coordinated effort by law enforcement and the people in the house to frame and plant evidence regarding Karen Read. That's their case. Based upon what I've seen and heard so far in the courtroom and the interviews that I've done, that's the bottom line to all of this. That is the bottom line. A juror, to find reasonable doubt on that theory, will have to believe that that theory is reasonable. And we'll see. We'll see what the evidence shows. Like if you have text messages or some level of coordination between these people who are alleged to be part of the conspiracy,
that's going to be easy.
Then maybe the jury
that's going to
buys
be
it.
easy.
Maybe that is the truth if you have that evidence.
That's going to be easy because you have the phone calls between Jen McCabe and Michael Proctor the morning of, before Michael Proctor was even assigned the case. You also have the fact that the Proctors and the McCabes have a personal relationship. You also have the fact that Jen McCabe was at the Proctor home well after the fact, well into the investigation. So when is it appropriate for a witness to go to the investigator's house for an interview? So an interview was not taking place. So it was absolutely inappropriate. So therefore, it's not going to be difficult to prove this to a jury. It is absolutely reasonable to think that Proctor spearheaded this investigation towards Karen Read with reason to do so, personal reasons to do so. It is not difficult to believe. It is very, very easy to convince a juror that this is a reasonable theory.
So there is, while there's no legal burden on the defense here, there's going to be a burden on them to try to.
Now, I always speculate as to my theory as to why they targeted Turtle Boy, because I know it's more than just to shut him up. They wouldn't be mentioning his name. This is the thing. If it was just to shut Turtle Boy up, they would not even mention his name in the hearings. They would not use his name in the motions. So let's use our brains here, folks, and let's use our eyes. All right. If it was just to shut Turtle Boy up, the idea is, if that's the case, it's because they hate the attention that he's getting. So if they're trying to avoid attention on Turtle Boy, they would not mention him in the motions that they filed, in the opposition motion that they filed, and they would not mention him in open court. that is being televised everywhere. So I don't think it's about shutting Turtle Boy up. I think that it's about the fact that they want to use his name in court. They believe that this is the thing. Turtle Boy is responsible for uncovering plenty of evidence. He's definitely responsible for uncovering the evidence that Michael Proctor and the McCabe's have a personal relationship. That the Proctors and the McCabe's have a personal relationship. This result is due to Turtle Boy's investigations. And this is being used as evidence to defend Karen Read. And it's very strong evidence that will help exonerate her. It's definitely exculpatory. The fact that there is a personal relationship, an absolute conflict of interest, that the Proctors and the McCabe's have a personal relationship. It is absolutely inappropriate. So Turtle Boy is absolutely responsible for uncovering this. Now, what I believe them jailing him for was to take credibility away from him. Because if the defense comes up and says, hey, and they use the prosecution, if the defense comes up in cross-examination and starts asking Michael Proctor about this and that and this and that and his relationship, blah, blah, blah. And then let's say Turtle Boy comes up on the stand, right? And they ask Turtle Boy, hey, so you're the one who brought up, who discovered this and blah, 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 right? Then what happens? The prosecution gets to tear down Turtle Boy through his credibility. They get to say, well, weren't you charged? Don't you have charges right now pending for witness intimidation, felony witness intimidation, harassment? Didn't you have an order filed against you for domestic violence? I mean, this is all stuff to destroy his credibility, because Turtle Boy actually discovered a lot of the evidence that the defense is planning to use to defend Karen Read, to try to exonerate her. So the prosecution is absolutely, their strategy here, as far as the evidence that they plan on using that Turtle Boy uncovered, their strategy here is to destroy Turtle Boy's credibility to a jury. That is what I am absolutely convinced of at this point. Because we followed Turtle Boy's charges. We absolutely followed Turtle Boy's charges as in real time, as everything was happening. Okay? And he absolutely was railroaded. A law was weaponized against him. And then he was absolutely set up by a woman who they took advantage of. They took advantage of the fact that she was pissed off and heartbroken. And they weaponized her against Turtle Boy. And I promise you, people, at this point, I am 100% convinced of it, that it was all to serve the purpose of destroying his credibility once the evidence is presented that he was responsible for uncovering goes to trial. Once that evidence is presented in trial, the idea is to destroy the source of that evidence's credibility. Turtle Boy, the YouTuber, the blogger, who's now has charges of felony witness intimidation. That's your source for information, defense? That's exactly where this is going. Mark my words.
Try to tie some of those pieces together in order for a juror to say, okay, that's an alternative, reasonable explanation as to what happened to Officer John O'Keefe. That's where you have to, and again, I'll get back to my premise here. I'm not trying the case from one side or the other. What I'm telling you is laying out what this trial is going to look like. And it's going to look like unlike any other case in the history of Court TV. Because of the passion, because of what has happened in the lead up to this trial, the people involved, and the cross allegations. This is more. I mean, you see cross allegations in civil cases, right? I'm suing you for this, or you're suing me for that. I'm going to counter sue you for that. That's kind of what the defense is doing here. You're going to charge her with murder. Well, we're going to accuse you of committing this murder and covering it up and framing her.
I admit it looks like that's what
Now,
they're doing.
I was trying to, I was thinking back,
But no.
and if there's ever been a case where it's been proven at trial that someone was framed by law enforcement, and I cannot recall one in the history of court TV. Now, there are cases where, one defendant is framed by another defendant, right? Like I've seen those. I don't think I've ever seen it in this context and to this level. Now, the problem for prosecutors is that the feds, like the Department of Justice, the FBI, is doing an investigation of the investigators here. And the results of their investigation are being shared with the prosecution and defense. When has that ever happened? Like during the course in the buildup to a murder trial, which is going to happen in April.
Now you're thinking, Vinny.
But at the same time,
you got
the
it.
feds are investigating the people who investigated the defendant and then sharing all that information. This is bizarro world.
I love this.
Never happened.
Because Vinny's just thinking out loud.
Never, ever, ever.
I'm loving this. Vinny is totally just thinking out loud right now.
Never, ever, ever happened. Let's see. Jennifer McCabe did nothing wrong. And
look who it is again, bro. Another $5. Jennifer McCabe did nothing wrong, nor did her children. Why did you support? Why do you see? Everything's an attack on Vinny.
Yeah, like she's not accused of anything, but she's being accused by the defense. And we'll see what the defense shows up with.
Right. Right. That's it. What is your problem?
Yes, Gen X, I get it. I get it. Okay, let's see. Why don't you speak about the forensic facts like DNA? I did.
Right. I mean, it's a great question. He has talked about that before. But I mean, all it takes is for him to, I would love to hear him, who has experience in a courtroom and has so much experience following so many cases. I would love to hear his take on on this, if Vinny has actually looked into all of the other evidence. Now, I don't think he has, and I don't blame him for not doing so yet. Okay, you got to understand that Vinny seems to be going through a pattern here, and he's starting to understand, and he's going mostly by the motions that are currently being filed, right? He might see Yannetti or Jackson say something in court, hear Lolly respond, and then he'll go, well, wait a minute, what the fuck? I've never heard of anything like this. I've never seen anything like this. And that could be all he's going by. He probably does not know that there's a 3-week gap between the photograph that was taken of John O'Keefe's clothing in the hospital and when it was logged into evidence. He probably doesn't know that. And that's okay. Like I said, I'm not attacking Vinny for this. I'm saying Vinny follows a lot of cases. Like for most of us that are following this case, it is what we're obsessed with right now. It is absolutely the case that we are following every single little bit of, because every single time something happens, it is crazy and unheard of. So I understand, like Vinny right now has that fascination with this case right now, but has not probably had time to look into everything that we have all been exposed to here. And he's probably trying to avoid getting his information from social media, which I absolutely, totally support. So, don't get upset with Vinny if he has like no rebuttal to this exactly that you would have, because Vinny has not looked at every single thing the way that most of us have. I haven't even looked into every single thing. So, I mean, there's this spreadsheet and it is beyond. I mean, it is beyond. You've got here. I mean, there it is. Save it. If you're watching on your computer, take that spreadsheet and save it and look over it yourself. It has everything that you need as far as documents on this case, thanks to Sleuthy Goosey. Sleuthy Goosey made this spreadsheet up, and it is essential to understanding this case. And I hope that Vinny gets a hold of this.
Here's the thing about this. I'm not trying this case for both sides. I'm giving everyone this view. If you've been watching the video, I said from the beginning, this is extremely layered, extremely detailed, this case. And I think in the comments, apparently you're seeing the passions on both sides here. And I get it. No one likes being accused of something they didn't do. Whether you're a defendant, if you didn't do it, or you're just an innocent member of the public connected to the victim in the case. You don't like it. Now, what's interesting is, one second. I spoke with Ben Chu, who's an expert in defamation law, libel law. He was the guy who represented Johnny Depp.
I got to say something that I forgot to say because I had to step away for a second. But when Karen Reed's dad was speaking, the quiet and the respect that it demanded, it felt as though, and this, I'm going to get a little corny here and disagree with me all you want, and that's fine. But for me, like someone like Grant not being there was divine intervention. I think that the public needed to hear from Karen Reed's dad, from Mr. Reed. I think that that everyone on the who watches the news and starts to follow this case needs to hear that from Karen Reed's father. And I think it was divine intervention that there was not someone like Grant there yelling and screaming and asking ridiculous questions and distracting the poor man from being able to get through his thoughts and express them publicly to everyone watching. I think that man has a hell of an amount of skin in this game. And the respect that he demanded by just simply speaking was granted to him, and it felt as though, you know, something made sure that happened. Believe that if you want or don't. That's what makes this country amazing.
And I presented this story to him, and he talked about because people are being accused of doing things here, and inside a courtroom, everything is pretty much protected. It's protected speech, and I guess it has to be for our system to function. Like, I guess the defense or prosecution can make these accusations. But when those statements and accusations are made outside of a courtroom, then it's a different case. And I'm wondering if there'll be, you know, that part of the case. Thanks for your objective coverage. Freeing Karen, a step towards justice. See, Deanna, I mean, people seeing this thing differently, you know.
She's like, thanks for your objective coverage on the case. Freeing Karen Reed is a step towards justice for Officer John O'Keefe. So it's a bit of a contradiction there, Deanna, in her super chat there. But at the same time, I feel the same way. I could probably explain that a little better, because I feel that freeing Karen Reed is definitely a step forward to getting justice. But I also appreciate Vinny's objective take on this case, at least not perpetuating the narrative that she's guilty without asking the right questions. And so far, he's asking the right questions, and that is all I ask. That is all I ask of anybody who covers this. Ask the right questions and realize, use your common sense, realize there's a lot wrong with this case. There's a lot wrong with this case, and it's undeniable. And Vinny is seeing this, and he's not made the decision that Karen Reed is guilty or innocent. He's just saying, I got questions. He's pulling Melanie Little 2 months ago. I got questions. That's all I'm saying. There's nothing wrong with that. That's all we want.
And I get it. I get why people are seeing it differently. Yes, I have. I have had people on my show on both sides of this story and this case. I absolutely have. And Robin, thank you. Robin from New Hampshire. Very heated today, very heated. And anytime you cover this story, like when we do this trial every day, my direct messages are going to blow up. Yeah, I get it. I get it. So this trial's coming up in April on Court TV. You will see it. You will hear all the evidence, and you make a decision. And hopefully at the end of the case, there will be a verdict one way or the other, rather than a split on the jury the way members of the public and the folks in the chat rooms and everywhere else are apparently split on this one.
I mean, it's got to be tough to be in a position like Vinny is in right now. You know what I mean? You got to cut up some slack.
Body was on the front lawn, about 8 feet in.
And because it's very telling. Like, the truth is, like I said, all Vinny has done so far is ask questions. And if you're bothered by this, that speaks volumes. If you're bothered by someone asking valid questions and saying the defense has a good shot here simply because they're raising some questions and they're doing something here that I've never seen before. That's it. I mean, if that bothers you, that speaks volumes about where you're coming from, because you should be asking the same questions. You should be asking questions. You shouldn't just be going, well, the prosecution says so, and therefore she's guilty. I mean, that is irresponsible.
About 8 feet in is the way it's been described. Mel Carter saying the injuries don't match. Again, you're going to have experts talking about that. You're going to have experts talking about that. And they're not going to agree. And it's not unusual in a case that you're going to have, in most cases where there's expert testimony, there's usually an expert on both sides. So this is where the jury has to listen to what the experts say, evaluate the experts' level of experience in all of this, and then see how it matches up with the other evidence in the case. And that's oftentimes what I've seen jurors do, is they'll look at what this expert said, what that expert said, and then look at the independent evidence. It doesn't go one way or the other. That is what it is. That is not really up for interpretation, and says, okay, does this expert's opinion match that evidence, or does the other expert's opinion match that evidence? And we saw experts in the Murdoch case. And Kenny Kinsey was, I mean, the way he talked, the way he explained it, just oozed of credibility. And the jury understood that. And I think the folks who watched the trial understood it. And ultimately, Murdoch was convicted. That case was not as big a case about expert testimony, but it was a facet of it. This case, much bigger, much bigger.
Sorry, I'm going to speed them up a little bit.
People think I'm paid to do this. I am not paid by anyone to do anything other than do my television show.
All Karen does is lie. So many changing stories. If I was a jury, I would never believe her. And then somebody.
People think I'm paid to do this. I am not paid by anyone to do.
I'm still waiting on a check, man. Let me say, hey, listen, Karen Reed, anybody, y'all want to throw me some money to be your PR person? I'm down. But the thing is I don't see anybody with a brain making me their PR person. I don't see anybody with a sense of logical and sound strategy making me their PR person. So, but hey, listen, I'm down. My email is very public. We'll talk turkey.
Do anything other than do my television show, in which for decades we've been doing. All right. Julie Grant has it right.
You don't want, I told you that before, Bob Brown. You don't want that either, man. You don't want me going up there and doing all the cross examinations. I'll get kicked out of court, man. I'll get put in contempt. I'll be hauled out of there like Hannibal Lecter. Like, there's no way. You don't want me doing that. That I promise you.
Just trolling, not trolling. I'm not trolling, but people are trolling. I'm scrolling through some of the. You need mods. That's true. All right, folks, I got to wrap it up here. I've got another podcast I've got to do. I'm actually a guest on that one. Lauren Katie has her blood on top of the snow if he died when Karen Reed left. That's going to be another issue. That's going to be another issue. It's snowed after Karen Reed, I believe. So that's more expert testimony there, Lauren. More expert testimony on this one.
I mean, that's going to be Vinny's logical answer.
I wouldn't say it's a weird
everything. Case. You know what I'm saying? He represents fucking court TV, dude. Like, that's going to be his answer for everything. You can't blame the guy. He's going to say, well, that's going to be expert testimony. Like, anytime somebody asks these logical questions, he's going to go, well, yeah, that's a great question. That's going to be for expert testimony. Which is true. So you're not going to get those. You're not going to get the kind of opinions out of him that you're going to get out of me, for instance, or Turtle Boy or any other YouTuber. You're not going to get those kind of. He's got a contract with. He's the face of a certain TV network, so he's only allowed to say so much.
Case, I would say it's an unusual case, and unlike any case we've ever covered. This is amazing. This is amazing. I'm just reading some of these comments. Like, okay, we're gonna get them. We're gonna get those moderators again for sure.
Yeah, he's got to choose those carefully.
This is interesting because this just happened. They
want to create
a buffer zone outside of the court.
He can't just start fucking handing out wrenches in the fucking chat, dude, to random people. You know what I mean? He's not just any other YouTuber. He's that's how me and Annie from 10 to Life met. because she was live streaming on YouTube for the first time. She had like thousands of people in there. It was like her first live stream. And I just kept blasting like with alert emojis and shit. Like, you need press on my name and blah, blah, blah. You need moderators. And then, yeah. But people who just start doing this, they don't really think about this. They don't, you know, they don't really think about the need for moderators and things of that nature. And of course, if this is split and people have been watching his coverage, then, you know, he's going to get some trolls in that chat, man. He's just going to get some trolls in that chat. That's for sure.
Courthouse. I've seen that done in other cases. It's been done in other cases where they set up a zone for protesters. Usually there's protesters on both sides of the case, but there's the balance of the First Amendment freedom of expression, but then they've got to keep things safe. And they also have to, in this case, in Dedham, Massachusetts, protect the jury. Now, the last trial I covered in Dedham, the jury would meet, because it was high profile as well, the jury would meet at an undisclosed location. The deputies would pick up that jury and then bring the jury in and sort of not sneak them in, but bring them into the court.
Now, let's talk real quick about, like, because how is, and this raises, I mean, this question being raised is inevitable. It really is. Sooner or later, how is this case, once this goes to trial and the case that the prosecution presents, how is it going to affect, let's say, the Brian Walsh case? You understand where I'm coming from? I worry about that. I worry about how the prosecution claims that the Cellebrite data there, I mean, because the defense is just going to poke holes in everything that the prosecution is saying about Cellebrite. That's exactly what they're going to do. They're going to bring their own experts up, and they're going to share the federal experts' testimony or findings. They'll probably call that federal expert up to the stand. So we have to think how irresponsible it is for the prosecution to say something like this: the Cellebrite data is unreliable because of a new version, an old version. I mean, it's ridiculous. It's a ridiculous, like, I don't want to say defense, because it's the prosecution that is in defense of this. That's what's weird about it. The defense is the one making this accusation. Like, why did Jennifer McCabe make a Google search of how long to die in the cold at 2:27 a.m.? And when they're saying, well, it didn't happen at 2:27 a.m. Karen Reed allegedly asked her to Google how long to die in the cold at 6:40 something or 6:20 something, I think. I don't even know. But the thing is like, if you look at the Cellebrite report has 3 different searches, and all 3 of them are worded differently. So how could one of them be the same search? How could the 227 search be the same search as either one of the 6 something searches, right? So, but when you think about what the prosecution's proposing, this could totally set a precedence to where Cellebrite data that has been applied and used as evidence and testimony to strongly convict, used as evidence to convict killers, murderers. And they plan on doing so with Brian Walsh. So tell me that this thought is not disturbing. Because, I mean, is it going to lead to having to overturn other convictions? What if the prosecution gets to go through with this and say, well, basically saying that the Cellebrite data is unreliable? So But the thing is I just don't see how that's going to happen. I mean, I think it's going to be very easy for the defense to prove that search absolutely happened at 2:27 a.m. I think so. I absolutely believe so.
The courthouse, and that's a small town courthouse. You know, there's a couple doors, as I recall, the front entrance and the back entrance to get into the courthouse. So we'll see how they handle that. I think they may create some restrictions on where you can be. I think they've done that already, but I don't know if they're going to try to put them across the street. But I have seen that in other cases. You know, in the build up to the Derek Chauvin, George Floyd case, they built places for people to be. The same happened in Ahmaud Arbery, although in that case they were much closer to the courtroom. It's a safety thing for the witnesses, for the jury, and everything else. So that's the balance that the court will have to do. But I think there will be some restrictions and some parameters set up for where folks can be by the courthouse, which is more common, again, I would say, in cases where you're talking about a racially charged trial. Yeah, this is good. People, you start insulting, people don't hear you. Billy, how are you, Billy? I'll tell you what's up. Everybody got all upset today. Everybody got all upset today. And that tells you the nature, Billy, of this trial that you must watch on Court TV. All right, people are arguing this. Yeah.
Yeah, I mean, you got to like Vinny, what you got to do, buddy, is you just got to wait and you got to talk to people who you trust and know, who follow you and can be in chat when you go live, and you wrench them, man. That's it. I suggest going with the ex-cops with channels. I suggest going with some folks that the people you've had on your panel trust. If I'm being totally honest, that would be my best advice to you, is to contact the people that you've had on your panel, that you've had good relationships with, who have YouTube channels, and ask them to ask their moderators if their services could be available. That would be my recommendation, in theory.
Oh, this is amazing. I think I saw that movie, right? The Departed. Right? Boston Police had but this isn't Boston Police. This is Canton and the Massachusetts State Police. This was not investigated by the Boston Police. So,
no. The Departed was the Staties. The Departed was the Massachusetts State Police. Absolutely was. The Staties.
Despite the fact that they had a little history there with, I think, Whitey and everyone else, and the local FBI had problems there as well. I mean, yeah, there's a little bit of history there. This is a little different than that type.
Dude, I've got let's see. Dude, I've got over 1,100 people.
Great to see you.
Watching on Twitter. Over 1,100 people watching on Twitter. Like, why that's happening, I have no idea. But you know what, man? That's for you guys. I appreciate you.
Thanks for joining us. I don't know. Yeah. Well, we shall see. Like I said, folks, it's heated, but you have to see it. And I get it. You know, both sides. Nobody likes being accused of something they didn't do, and the truth will come out in the courtroom. But at this point, everyone is presumed innocent. Everyone is presumed innocent.
Right.
But members of the public are allowed to have their opinions.
Sure.
Right. That presumption of innocence is how our system treats people. It is how a jury is instructed, and how a jury must accept a defendant. But in our country, because of the freedom we have, people can have whatever opinions they want. And in cases where some of the evidence has come out, not all of it, where some of the evidence has come out, people are allowed to have their opinions. And that's what's happening here in this particular case. But the opinions are very passionate and very specific. And the allegations that have been made by Turtle Boy and others.
See, Iris, you're proving your own point against you right there. You're saying, the way I see it is, prosecutors can't take a case to trial without believing in its evidence. There are rules. And you are absolutely 150% correct on that. But what I'm seeing by you posting this comment is the fact that, since you are sitting here and you believe in the prosecution this much, You're failing to acknowledge the fact that the defense filed a motion to disqualify the Norfolk County DA's office because they do not believe in the evidence. There's evidence to indicate that they do not believe in the evidence, that they have not followed the rules of evidence and have not followed the rules of chain of custody. They have not followed the rules of bringing it into discovery before trial. So there's just a lot of problems with how the prosecution is handling this case, and has handled it from the beginning, from the investigation to begin with. That's why we're all here. That's exactly why we're all here. We believe, those of us who believe that Karen Read is innocent, believe that the prosecution has handled this case in a very, very nefarious manner.
Seemingly are being echoed in the courtroom by Karen Read's attorneys. So it gives you a flavor for how this whole thing will go down. Oh, Joyce, I just have to point something out. Joyce, the martini glasses in the background. These were actually Court TV swag. I don't know if you can see it. Can you see it?
Court TV.
It's got the Court TV logo on it. And years ago, it used to light up. And this part here was like a little DNA strand. This is a little DNA strand. It's old Court TV swag that I kept for all these years. But actually, don't. And mufflers. That's a question the defense, I think, would have to answer. Is it just to protect the people inside the house because they're all somewhat friendly? That's the great question. And you'll hear that, I am sure, from the district attorney's office, from the Commonwealth, from the prosecution. Why would they go after her? Yeah. Some fiery comments and questions today. Okay. All right. So we shall see. Thank you, everyone. Even the trolls. Just don't make it personal, because there's nothing personal about it from my perspective. I said I have no dog in the race, horse in the race, but one agenda, which is to see the evidence come out and see the truth come out inside the courtroom. And if you report this case and you don't report what the defense is saying, ethically, as a journalist, you're not doing your job. You're just not doing your job. And I've reported both sides here. Now, like in the Madeline Soto case, it's difficult to report the defense side because they haven't spoken. They haven't said anything. So we report what we know. And we report who's saying what. Like he made statements. In the Soto case, Stephen Sturz made statements. We reported what he said. We took a look at his story. We reported his story, that he dropped the little girl off. But we're also reporting the prosecution story. I think you have to understand the way this works in the courtroom and in the media. I've been covering cases for decades. Always.
Vinny's over here spitting
I've
facts.
explained what both sides are alleging and arguing in every trial I've ever covered. Every trial. You don't avoid one side. And that's what you see sometimes in some of these podcasts and docuseries, et cetera, where they really latch on to one side and not the other, and they don't tell the complete story.
On Court TV. Come on, Vinny.
Well, the beauty of Court TV is you get both sides because we show you all the evidence, so you hear the witnesses.
Well, we are. In his defense, in his statement right now, we are getting both sides because Vinny is providing that, and Vinny represents Court TV. But if it wasn't for Vinny, Court TV would not be presenting both sides, and Vinny is only starting to really do that. So let's just be honest here, Vinny. You know, but it's appreciated that it's happening now. Better now than never.
The testimony. When papers are filed in court, we'll talk about them. Much more even. Why? Because we're doing our jobs. And we have our opinions based on the evidence. But I've said from the beginning, I don't have an opinion on this one. I have an opinion on Stephen Sturz based on what I've heard so far. This one I don't.
I mean, Vinny, I'm calling bullshit on that. I mean, I'm not saying that you've got an opinion as far as picking a side. Maybe that's exactly what you specifically mean. Whether she's innocent or guilty, I get that. I haven't even 100% chosen that she's innocent. I believe it. But again, I'm still waiting. But I just don't believe that that's the case. I do not believe that there is some sort of smoking gun that the prosecution is going to bust out at trial. I just don't think that that's happening. So I'm at about 97%. Karen Read is innocent. I'm at about 97%. Realistically.
I could tell you, what my initial reaction was to this story was, oh, they're out drinking and someone got hit by a car. That makes sense. I've seen that before.
Like,
driving.
I wasn't there. You know what I mean? I wasn't there. That has to count for at least 1%. So no matter what, it's always going to be 99. You know what I mean? I wasn't there. So that's got to count for at least 1% right there. So yeah, I'm at about 97.
Driving under the influence and striking someone. But that's not the allegation here. The allegation isn't some accident. The allegation is something else. So in reality, the truth could be what the prosecution is alleging. It could be what the defense is alleging. It could be something in the middle, something that neither is alleging at this point. Although at some point, both sides seem to be alleging this, that it was an accident. We shall see. Carry on. All right. I've got to roll. I've got another interview that I've got to do, but I appreciate all the support. I appreciate the lively chat. And I'll try to read some more of these comments because, again, as I'm doing the show and speaking, I can't keep up with what people are saying. But we will get those moderators inside the chat because apparently people are getting very personal, and that's not good. Argue the evidence. Don't make it personal. All right. Thank you. Don't forget tonight, 8 o'clock, 8 to 10, Court TV, 2 hours live every night, Monday through Friday. Then I've got my show on the weekends at 10 a.m. And we're also currently filming season 2 of Accomplice to Murder. I'm Vinny Politan. Have a great day. And please don't forget.
Politan. Now I know how to say his name properly. Politan. All right. So let's go over this motion. I got a little bit of coffee left. So all right. So the Commonwealth's motion, now they just filed this just after the hearing. Okay. So the Commonwealth's motion for buffer zone surrounding Norfolk Superior Court and request for order prohibiting signs or clothing in favor of either party or law enforcement. So right there, this is an attempt to basically stifle the freedom of speech, the First Amendment rights of the people of Canton, Norfolk County, and the Commonwealth of Massachusetts. So the very people that the Commonwealth of Massachusetts represent, right? Because it is the people versus Karen Read, right? It is the people of the Commonwealth of Massachusetts versus Karen Read. So if they are going to represent those very people who are standing on those court steps, they should support their right to stand out on those court steps and be heard. It's their right to do so. And so now what you want to do is file this motion to stop people from doing it. And if I had to guess, and I haven't read this yet, if I had to guess, you're going to apply this bullshit law that you applied against Turtle Boy and applied against the Canton Nine. Let's just be real here. Let's take a read. Let's read it. See what it says. The Commonwealth respectfully moves to this honorable court establish a buffer zone around Norfolk County Superior Courthouse in Dedham, Massachusetts during the trial in this case. This case has been the subject of substantial media coverage. There have been demonstrations on the sidewalks in front of the courthouse, on the courthouse stairs, on the stairs and sidewalks in front of the Registry of Deeds, and instances of individuals confronting and following potential trial witnesses to and from their vehicles for appearances at court proceedings. During these demonstrations, individuals often carry Free Karen Read signs or posters with their interpretation of the evidence. Individuals have also amplified their voices with bullhorns to yell at potential witnesses or promote their theory of the case. The demonstrations also feature individuals and animals wearing Free Karen Read or similarly messaged clothing. There is a substantial risk to both the defendant and Commonwealth's rights to a fair trial that would be jeopardized if prospective jurors are exposed to the messages contained in the demonstrations, especially before this court has had the opportunity to instruct trial jurors about their obligations to remain fair and unbiased. Further picketing and demonstrations at the courthouse during the pendency of the case would expose jurors to extraneous matter that could prejudice both parties. See Commonwealth versus Louder, blah, 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 blah. General law, blah, blah, blah. And then it says here, whoever, look, here it is, 268.13a. Whoever this, with the intent of interfering with, obstructing, or impeding the administration of justice, or with the intent of influencing any judge, juror, witness, or court officer in the discharge of his duty, pickets or parades in or near a building housing a court of the Commonwealth, or in near a building or residence occupied by, used by such judge, juror, witness, or court officer shall be punished by a fine, if not more than $5,000, or by imprisonment for not more than 1 year, or both. Nothing in this section shall interfere with or prevent this exercise by any court of the Commonwealth or of its power to punish for contempt. So there it is again. The Commonwealth requests prominent posting of 268.13a and in the around the courthouse immediately before April 16th, 2024, and during the pendency of this trial, to notify any persons planning to picket, parade, or attempt to influence jurors or otherwise impede, interfere, or obstruct the administration of justice have actual notice of the possibility or of prosecution for such actions. Further, the Commonwealth reposts an order prohibiting any individual from demonstrating in any manner, including carrying signs or posters or making statements about the defendant, law enforcement, the Norfolk District Attorney's Office, potential witnesses, or the evidence within 500 feet of the Norfolk Superior Court complex, which includes the parking area behind the Registry of Deeds building during the trial of this case. See attached map with proposed 500-foot buffer. The Commonwealth also moves for an order prohibiting anywhere where prospective jurors gather or walk to the courtroom. The wearing of or carrying of papers, water bottles, tote bags, signs, buttons, pins, t-shirts, sweatshirts, hats, or any other attire or item that contains any images or writing that suggests a favorable or unfavorable opinion of either party. Information regarding opinions that members of the public have about this case are irrelevant and may be prejudicial to the Commonwealth and or defendant. Wow. So further, the Commonwealth requests that the court expressly prohibit any individual in the courthouse from wearing any buttons, shirts, or insignia related to the defendant, the victim, or law enforcement, sex after midnight, including a prohibition of law enforcement officers who are testifying or are members of the audience from wearing their department-issued uniforms or any police emblems, to the extent that the court requires assistance or specifically articulated mechanism to enforce the proposed buffer zone. The Commonwealth proposes that the court could request assistance from the Dedham Police and or Massachusetts State Police, both who have been previously deployed to maintain security and safety during the prior court proceedings. So therefore, they want to weaponize the cops Wow. So here, respectfully submitted for the Commonwealth, Michael Morrissey by Adam Lawley. Fascinating here because so yeah, this is basically it's just saying that nobody can protest. Nobody can say, nobody can wear a Free Karen Reed t-shirt on the courthouse steps or within 500 feet of the courthouse. So this is the thing, folks. Because I gotta say that I'm pretty fired up. Changing my background because anybody who is following this case, and if you believe in your freedom of speech, if you are someone who follows true crime and you believe in freedom of speech, you will know that this is absolute and utter fucking bullshit. And you should be speaking up on it. You should be blasting this behavior of this attempt of the prosecution, the DA's office, which is under federal investigation right now. A DA's office, which is currently under federal investigation, attempting to weaponize a bullshit unconstitutional law against people, peaceful protesters exercising their freedom of speech by standing on the courthouse steps, simply wearing Free Karen Reed t-shirts, cheering for her when she walks in, showing support, and showing a protest against the Massachusetts State Police. So if you care about your freedoms, then this is something that you should be speaking up on all your social media, blasting this all over Twitter, blasting this all over Facebook if you're on it, blasting it all over Instagram, everything that you've got. This is disgusting abuse of power. It's a demonstration of an abuse of power coming from the Commonwealth of Massachusetts right now. It just is. I mean, there's no denying this. This is exactly what the defense are accusing the DA's office of doing. Because this should have never gone as far as it has. If Proctor had conducted a sound and thorough investigation in the first place, those people would not be gathered outside. Those people would not be gathered outside. If Karen Reed is guilty and Proctor had conducted a sound, thorough investigation, I mean, we wouldn't, these people would not be gathering outside that courthouse like that. They just wouldn't. So, I mean, everything that we've seen the Norfolk County DA's office do makes it very believable that they are capable of doing what the defense is accusing them of doing. And what they are being accused of is absolutely un-American. It's just simply un-American. So you can't support this if you value freedom. It doesn't matter if you're a Democrat, it doesn't matter if you're a Republican, it doesn't matter where you lean politically. If you're an American and you're a patriot and you believe in your freedom, this is a clear weaponization of the law to try to torpedo people's freedoms. And that's all this is. So, Cherry shortened it. She did a great job. When I try to post it, it's too long I mean, the audacity to say, hey, these people can't show support. These people can't express. This has never been done before. You know how many trials there have been people out there on the courthouse steps, and nobody dared to try to take the freedom away from those people. Nobody dared to try to do it. America wouldn't stand for it. If America was watching this trial on television, I'm talking about in the 70s, 80s. If America was watching this trial on television, do you think, I mean, think about how that would have gone if they tried to pull that shit with the people crowded outside of the OJ trial. Think about how that would have gone. Can you imagine if they tried to tell the people outside of the OJ trial on the courthouse steps that they couldn't be there with signs, t-shirts? I mean, come on. Is this where we're at in this country, where we don't care about that, about how important this is? This is not some light thing here. This is not just some little thing. This is basically the prosecution in this case, which is under federal investigation currently for their tactics, for misconduct. Okay? And right now they just filed a motion to try to take away everyone's First Amendment rights, to impede on all of their First Amendment rights would be the correct way to put it. Nobody should be standing for this. This is something that both CNN and Fox News should be talking about. Absolutely 100%. I mean, this is disgusting. I mean, it tells you something about the audacity. You know what I mean? It tells you something about the audacity, the brazenness of Michael Morrissey. You know, it just tells you something about that. Nobody's ever done that. I don't think any DA has ever done that before. Blatantly tried to impede on a mass amount of people's First Amendment rights. The very people who they're supposed to be representing in that courtroom against Karen Read. That's fascinating, isn't it? And you're trying to take their rights away. And you're claiming to represent them in the case against Karen Read. Those are the people you claim to represent. The very people that are standing out there on those court steps. And you want to impede on their right to free speech? How's that going to go? You know what I mean? Like, I really hope that this gets the national coverage that it deserves, because this is fucked up. I hope Vinny talks about it. I hope Court TV talks about it. I mean, because you've got to admit, it has to be addressed. It cannot be ignored that this is unprecedented, right? It can't be ignored. When have you ever seen a DA's office try to take away the First Amendment rights of a mass amount of people that are there every single time to applaud Karen Reed when she walks into the courtroom. They're not spitting on nobody. They're not, you know what I mean? They're not throwing nothing at nobody. They're just out there. Just they go to the Dollar Tree and buy their shit to make their signs. They buy their t-shirts. It's there's nothing more American than this. This is the epitome of what exercising your American rights are peacefully. It's an absolutely beautiful thing to witness. That's why I appreciate Tom so much, because Tom goes out there and he shows everybody doing this. You know, not to mention, of course, you got Paul and Dana. I mean, it's insane how, you know, like Rita and I mean, it's seeing all of those people out there just consistently out there. And it's because they're being lied to. It's because they're being misrepresented by by the Commonwealth of Massachusetts. And then now they're going to be their First Amendment rights are going to be attacked by the very people who claim to represent them. So, yeah. Everybody should be pissed off about this. I don't care which side you lean on. Everyone should be pissed about that. Everyone should be angry about about that. Absolutely. But guys, I had an excellent time with you guys. Thank you guys for indulging me for 4 hours. I appreciate it. I enjoyed hanging out with you guys. Thank you guys to all you guys on Twitter, man. 1,200 of you, over 1,200 of you guys watching on Twitter. That's crazy. But thank you. I appreciate it. So sorry, I'm just reading a couple of more comments real quick. UN handle of the day, by the way. UN handle of the day. Brian Albert's butt dial. Absolutely. I love it. Oh, man. Well, guys, yeah, I really appreciate all you guys. You guys are absolutely fantastic. And a big shout out to Vinny from Court TV, man. I've got his stream pinned, the link to his stream pinned. If you guys take a second on your way out, click on that stream that's pinned, click on that link and give the video a like and subscribe to Vinny Politan from Court TV. That's his YouTube channel. Yeah, man, you guys are absolutely fantastic, man. Thank you for hanging out with me. I don't think I'm gonna go live any later tonight, but maybe tomorrow. I don't know. We'll see. Anyways, I love you guys, and we will do this again very soon, my friends.